2011 matter হবনি হবনি
Then prefer pass over this matter to second of my lord.
It will
Item number 32.
My lord, want to
Due to ill health of my father-in-law, only adjourn this matter to some other date.
all right. This matter 1 week after okay we will date kar diyo 14th August.
My lord, want to mention the BLAPL 6747 by 2024 as it is a tied up matter and previously interim bail was granted by.
File a memo.
I pardon, but
Item
RSA
number
7721. RSA 7721. Old man. but-
File a memo.
My
but
lord,
already I have two
number
memos
30.
already filed.
Supplementary list.
But two memos already filed.
Take it off next week.
Which one?
Item number 31, supplementary list.
All right, next week as paid for.
I mean, pardon, my lord. Item 10 for supplemental. Maybe withdrawal, I mean, the file a memo for withdrawal of the.
All right, permitted to withdraw.
But two memos are already filed, but not listing the. 77.
Yes.
But RSA 7721.
ମୁଁ କହିଲି ପରା ମେମୋଟା ଦିଅନ୍ତୁ ଦେଖିବା ମେମୋଟା ଦିଅନ୍ତୁ
Two memos already filed.
କରିଛନ୍ତି
Yes, I'll.
have you filed the memo today?
Yes, two memos already filed.
All right,
But not listing.
supplementary list item number 1 fresh admission.
Please, my lord. My lord, my prayer is to transfer my ST case number, that is 28 from Session Judge Boudh to Session Judge Sonpur.
This why?
Because initially the trial was there before the Session Judge Sonpur.
Yes.
Due to bond call, frequent bond call by that court for that regarding the establishment of the High Court bench, it was directed the matter to be transferred to the both. So and now the court is usually functioning. So this is far away because they are all heart patient. Let it be transferred.
All of you are hard patient.
All the three are heart patient.
Sorry.
I have given the certificate also.
No, certificate କଣ ଆପଣ କହିଲେ ସେ ଆମେ ବିଶ୍ୱାସ କରିବୁ take instruction.
ଅନ୍ୟ ground ବି ଅଛି, hand in glove with prosecution ଏସବୁ ବିଭିନ୍ନ
Right, but this was a I mean policy decision taken by the at the instance of the High Court by the government at the relevant time. That is no longer in I mean many cases were transferred to the nearby districts.
What is the stage of trial? Because case of 2016.
Then State Council shall take instructions with regard to the status of the trial, as also the grounds taken in the transfer application. List this matter the week for
14th August.
on 14th August.
Item number 2.
Mother, there are two transfer applications. One is filed by the husband, another by wife.
Yes.
Let a copy of the first one be solved.
That will be solved, but I think if both have filed, it is better that you go to mediation.
No,
Mediation जाई पहले
केबे fail ହେଲା? When was it referred to mediation?
sent in the second item.
Okay.
Mediation report is
Mediation
there.
report is there.
Okay.
Failure report is
It's a failure report. Okay.
there.
All right.
ଯଦି failure report है कि से restitution of conjugal rights ପାଇଁ
All right. So you give a copy of the transfer application.
मोटा stay करबो
No, stay पे होगा. Adjournment होगा. Adjournment stay होगा. Transfer.
appear करिया पड़बो ना सेठी
हाँ, adjournment होगा.
adjournment रे गोटे वकील जीवन appear
हाँ, करिबो कोन? ସମସ୍ତଙ୍କ ପାଇଁ ଯାହା ଅର୍ଡରଟା
କରିବ
ଅଛି
stay ହେଇଛି मोटा stay ହବନି
ନା ଆପଣ stay ହେଇଛି
Not proceed ex parte. That was the order.
ଆମ ସେଇ order ବି
ନା ମୁଁ ସେମିତି ଅର୍ଡର ପାସ୍ କରିବିନି ମୁଁ ଯେମିତି ଜାଣିଛି ମୁଁ ଯାହା ପ୍ରୋସେସ କରିବି
ଆଜ୍ଞା ମୁଁ କହୁଛି ଯେ
ନା ଆପଣ କହିଲେ ସେଇ ଅର୍ଡର ପାସ୍ କରନ୍ତୁ ବୋଲି ମୁଁ କାହିଁ ସେଇ ଅର୍ଡର ପାସ୍ କରିବି
ନା ମତେ stay ଟା ଦିଅନ୍ତୁ
ସେଟା ଗୋଟେ କଥା ଅଲଗା ଆପଣ ମାଗନ୍ତୁ
ଆଜ୍ଞା
ନାଇଁ ସେମିତି ତ କିଛି ନାହିଁ there is no such order.
second item ଟାରେ second item
Second item is 350.
ଆଜ୍ଞା
My lord.
ସେଟା wife file କରୁଛି
8/11/2023. Order number 1.
Order number 1.
Yes, sir. The paragraph number 5.
Proceed ex parte. All right. Let a copy of the transfer application. That a copy of the transfer application has been served on Sri S.K. Das, who has entered appearance for the husband. Husband?
no wife he is for wife
Wife.
Okay. For the wife. In court. List this matter.
14th August.
14th August. आइए Further proceedings in MAT case number 14 of 2023. Pending in the Court of Learned Civil Judge, Senior Division, Holly Court, shall remain stayed till the next date.
Item number 3. The claim for pension, I think it is not assigned to this bench.
No, this is a Sikha Sahayak matter. Isn't it?
Counting the period of
Sikha
Sikha
Sahayak
Sahayak,
regularized.
he has already been regularized and he's claiming pension. Taking into consideration that particular Sikha Sahayak.
No, is it not assigned to this bench?
It is a regular claim of a person, my lord, on
For
the
pension.
Pension.
of a regular teacher. So
Place this matter before the assigned bench.
Item number 4.
May I please, your wordships? Lord, I have challenged the selection of
Why the selection?
the private opposite party as Anganwadi helper, not selecting the petitioner as such. Your Lordship may kindly see the advertisement. Your Lordship, straightway come to page 12.
Page?
Page 12,
Yes.
clause 2. ବୟସ 1/1/2024 ରିଖରୁ 18 ରୁ 35 ବର୍ଷ ମଧ୍ୟ ହୋଇଥିବ, ଶିକ୍ଷାଗତ ଯୋଗ୍ୟତା ଅନ୍ୟୁନ +2 ପାସ୍ ହୋଇଥିବ. Your Lordship may kindly see the page 18. I have secured 265 marks. Your Lordship may kindly come to page 22.
22.
Madam, my Ranu Mohanty, serial number 3.
Yes.
Against the marks secured in +2, it is mentioned as 213 instead of 265. I have passed +3. 5% additional mark will be added. So it will be 49% somewhat. He has secured 47%.
You'll have to file an appeal because appointment order has been issued, means you have to file an appeal.
No, my lord. It's that guideline doesn't permit, my lord, for appeal. Only Anganwadi worker.
no, no,
It is Anganwadi helper.
No.
The meeting-
Nua guideline ro achi, apan
the
dekhiye.
last page, my lord.
Look at the last page of the guidelines. There, the guideline ta dele. There are two appeals have been provided. There.
Yes. Two steps.
First appeal and second appeal.
That is for Anganwadi helper.
No, I'll just show you.
First hଉଛି sir Anganwadi worker. Middle hଉଛି mini Anganwadi.
This is
Last hଉଛି Anganwadi
this is Anganwadi help work.
Helper.
The last two pages, my lord.
Anganwadi helper.
Anganwadi helper. ଏଇଠି ଦେଖନ୍ତୁ.
The last two pages.
Guidelines for selection of Anganwadi helper.
Helper.
ସେଥିର
So ସେଥିରେ 2A pages.
the sub collector will be the first appellate authority.
Authority.
Or also for hearing complaints regarding selection, disengage. Your selection ଆସିଯିବ. Any person agreed with the decision of the sub collector may appeal to the district magistrate, ADM of the concerned district, the second appeal. କରିଦେବା।
I am not my.
No, ନୂଆ guideline ଟା ଆସିଛି, everybody doesn't know. I also didn't know he produced it. The petitioner seeks to challenge the appointment of opposite party number 5 as Anganwadi work helper of
Of my lord Birgoi.
Bellabari Anganwadi Center, and consequentially her own non-selection, despite securing more marks. Stuff.
That is my Anganwadi OP number 6. Your Lordship.
6 तो कोई चीज नहीं.
I
This court finds that as per the revised guidelines for selection of Anganwadi workers / mini Anganwadi workers / Anganwadi helpers dated 15/3/2023, the remedy of appeal has been provided under clause
Yes.
2F to the sub collector as the first appellate authority, and thereafter to the district magistrate / ADM as the second appellate authority. Since alternative efficacious remedy exists, I am not inclined to entertain this application at this stage. The writ application is disposed of, granting liberty to the petitioner to prefer appeal before the concerned sub collector within 2 weeks from today. Time भी है ही नहीं.
26 order.
Yeah?
26 order.
ना 26 वाला time मिला.
30 दिन.
30 दिन भीतर time मिला. You can file करते 6-7 within the time.
Yes.
Within 2 weeks. If such appeal is preferred within the stipulated period, along with an application for condonation of delay, the same shall be considered liberally, having regard to the fact that the petitioner comma, rightly or wrongly, comma, had approached this court. Yes.
If it is filed, my lord, that may be disposed of within a stipulated.
The the appeal shall be disposed of after granting opportunity of hearing to all concerned within a period of 2 months. Thereafter.
Replo.
Item number 5.
Your Lordship.
GRS promotion matter, your lordship, as per notification under annexure 5, your lordship. The government has published one notification to promote the GRS who have completed 5 years of continuous
Is
service.
there any word used as promotion, Mr. Sahu?
Absorption has been mentioned, your lordship.
So,
My lord, since 2007, the petitioner has been working.
what has happened? What has happened?
Lord, here difficulty there is while he was continuing, he was disengaged on 13/10/2020, your lordship.
1310?
2020.
Okay, then
Thereafter, as per direction of this honorable court, he was reinstated in his service, your lordship.
where is that order?
My lord, your lordship. Relevant page 23, starting 23, your lordship. Relevant person is at page 25, your lordship. Paragraph 7, your lordship, page 25. In such view of the matter, there was no cogent evidence found by the.
Reinstatement আছে.
Yes.
So it will go back to that date. Nahi, reinstatement হলে
That has been carried out, my lord, at annexure 4.
is hereby temporarily engaged as grammar reviewer civil.
Yes,
No, this is wrong. He should have challenged this order also.
that has
Also.
not been said.
You should have challenged this order. The direction was to reinstate you in your former post. Now this is a fresh appointment and that is why you have not been absorbed. I leave it open to you.
Extent, my lord, he has made a
My lord,
representation.
with that observation, your lordship, I have given repetition before the collector, your lordship. I kindly direct to consider on.
How can the collector consider?
He
আমার 5 বছর হয়নি না, if you calculate it from 11/12/2023, 5 years of service is not there. So how can you be considered for absorption?
Check.
Unless you are treated as reinstated. Reinstated means it will go back to the date of disengagement.
Yes, your lordship.
ସେଇଥିରେ ହେଇଥିଲା ଆପଣଙ୍କୁ 5 ବର୍ଷ ହେଇଥାନ୍ତା.
My lord.
I don't know, 5 ବର୍ଷ ହବ ବୋଲି ଭାବୁଛି.
My lord, prior to my disengagement, every year my post was renewing, your lord.
That is on a contract basis.
My lord, every 1 year, therefore they have given on such appointment, your lordship.
No.
That is also fact, your lordship.
Nothing can be done. Yes.
Every year, they are renewing the post of GRS.
Later, the first stage, my lord, the collector made, considering
What's-
repayment.
All right.
My lord, that
Annexure 7.
relevant person of the dishonorable court order, your lordship, may kindly be reflected in.
See, so what would have happened is, in the previous writ application, see, well, I should not say, but there is also no concept of reinstatement against a contractual post. Against a regular post is the question of reinstatement. So in contractual post, at least if an order would have passed that he would be treated as continuing in service subject to for future renewal of his contract,
Yes, my
then
lord.
the matter would have sufficed.
That's
Here, it's in a difficulty. So the rules are very clear.
my lord.
Rule is very clear.
Very
5 years of continuous service,
My lord, 5 years of continuous service.
subject to other conditions and relaxation of age.
My lord.
So that becomes difficult. All right. We'll direct the collector to take a decision. Thereafter, we'll see. In the meantime, you think of challenging the engagement order. That's engagement.
My lord, engagement order, ସେଇଟା ହିଁ ରହିବ because this is a contractual post, your lordship. While they engage me, the fresh undertaking, they will
All right, all right.
ask
The
from me, your
petitioner
lordship.
was working as, is working as Gram Rozgar Sevak, having been engaged with effect from
My lord, effect from your lordship 21/11/2007.
21/11/2007 at Patkulunda Gram Panchayat under Borpali block of Borgod district. he was disengaged from service. He was disengaged by order dated 13/10/2020 of the collector, come DPC, DRDA, Bargod. He challenged such disengagement before this court in WPC number 37307 of 2020. By order dated 31/10/2023, a coordinate bench of this court found the order of disengagement to have been based upon conjectures and surmises, and accordingly, inter alia held observed as follows. Inter alia held as follows. Paragraph 7 ta quote kar debe from page number 25. है ना? ये order. The petitioner was subsequently issued with an order of engagement by order dated 11/12/2023. Stop. It is his grievance that he has not been considered for absorption in the post of accountant cum data entry operator in Gram Panchayats, blocks and districts on regular basis as per the Odisha accountant cum data entry operator bracket method of recruitment and conditions of service rules 2024. This court finds that highlighting his grievance as such, the petitioner has submitted a representation addressed to the collector, Bargod, which is said to be pending. Since it is for the concerned authority to consider the grievance of the petitioner and take a decision thereon, the writ application is disposed of, directing the collector, Bargod, to consider the representation so submitted by the petitioner within 4 weeks.
Yes, ma'am.
Within 4 weeks from the date of production of certified copy of this order by the petitioner.
I cannot take one emphasis may be given order
Yes.
passed by this honorable earlier bench of this.
I've quoted it. I've quoted that order. So it becomes part of that order.
Melody. It will come to September. It was
Password matter, Mr. Rai.
yes.
Password matter.
My lord, I have informed that lady, but due to her illness, she couldn't able to come with my lord, sir.
As requested by Sri Rai, let us transfer the petitioner, list this matter.
2 chapter
7th
August.
Eh?
7th
7th August.
of pleasure.
Item number 7.
I have 7 that matter. Anganwadi worker. My lord, advertisement issued in 2009. 8 candidates applied. One did appear for verification of the papers, certificates. So 7 candidates. Out of 7 candidates, I secured the highest mark. But my certificates were verified. But thereafter, they didn't, my lord, publish the result. So after waiting for some time, I came before this honorable court. This honorable court was pleased to direct them to take immediate step in the matter. No step was taken. Once again, I came before this honorable court, and this honorable court was pleased to pass an order directing the collectors to take step in the matter. And thereafter, the entire process was declared to be null and void. That is the case challenge before your lordship. Your lordship was of the view that whether I have a right to post, I don't have a right to post. But in view of the situation, I have a right to be considered, and I have a legitimate expectation to be considered. That is the issue before your lordship. So my submission in this regard is in the similar, my lord, another center in 2015, they have given appointment to the Anganwadi worker as per the direction of this honorable court. After going through the entire thing, the honorable court was pleased to direct them to take a decision within 6 weeks. Thereafter, they have given appointment. So in my case, my submission before your lordship is that change of service area, my lord, after selection process was over. Right now, they have come up with a case that there was a change in service area for which it could not be done. Whether this plea is acceptable or not. That is the issue also before your lordship.
Yes.
With respect to the other facts, my lord, there is no dispute.
Yes.
Now, when a decision was required to be taken after lordship's order, they took a decision in this respect that there was a dispute with respect to the service area. So the matter was referred to BLCC because that service area which was defined in terms of which the advertisement was issued and the selection process was commenced. That is not in terms with the guideline of 15/2007. It requires minimum 400 number of persons to declare a particular area, and there were 364 persons. So that is why it was required to reschedule that particular service area. So when this matter was placed before the BLCC, they could not finalize it, and it was kept for a long period. And taking into consideration that the service area has not yet been finalized, and it is the one which has already been finalized, that is not in terms with the existing rules and regulations. That is why, my lord, they cancelled that particular selection. That is what it is available in the impugned order. And we have also stated in the counter, my lord, the same thing. In the right of consideration has not been denied and it has not been, but the selection process, when they consider the case of the petitioner, it is not that the case of the petitioner has been arbitrarily rejected. 8 number of candidates were there, but it is with respect to the service area. Since they could not finalize it, with respect to the service area, they could not finalize the selection. This is
How? Where is the advertisement?
Advertisement is annexed to my lord 1. No, my lord, sorry. Advertisement, my lord. Advertisement.
আমি মেনশন করেছি
Advertisement of what I probably
Having once advertised
Yes,
for a particular area.
yes.
So that advertisement was cancelled when? After the selection process?
No,
Then?
The selection process was never completed.
Okay.
When the selection process was on and there was inviting the objections, then the villagers, they objected. And taking into consideration their objection, it was actually found that the service area which has been defined there, that is not in conformity with the guidelines, it is in force. So that is the reason, my lord, they referred the matter to the BLCC and they could not come to a conclusion. And it was kept for it kept pending for years, my lord.
Then?
So thereafter, your lordship directed to take a decision in that regard. So they took the decision, my
Where is
lord.
that input order?
my lord, that is.
Annexed of
Annexed of
4.
4.
And
My lord,
order
question is, my lord, objection is always invited when the notification was issued. Not after the selection process started.
So, Mrs. Jana, you see,
Yes.
there can be no estoppel against law.
No.
If the guidelines prescribe, provide that only an Anganwadi center can be established with only 400, minimum 400
Yes.
people, then you cannot,
My lord,
even if you, only because you have issued an advertisement wrongly, the government cannot be bound by it.
my lord, that is true. That is one part. But whether that is available to them, that question is available to them right now. My lord, 2009, I came before this honorable court in 2011. They sat over the matter. Had it been so, this could have been cancelled then and there.
All right, all right. Even supposing your contention is accepted, can any mandamus be issued?
My lord, mandamus will be issued if the right has been infringed.
Your right has been infringed, but you have never been selected.
No, selection process has started. Question is, after the selection process was started, they have come up with a case that there
No, no,
was
your claim has not crystallized into a vested right.
no, I don't have a vested right, but I have a right to be considered.
Yes,
And
certainly.
apart from it, my lord, they should not, my lord, sat over the matter for so long.
Now,
My lord, since 2009, my lord, the order was passed in after your lordship's direction in 2015, and till that day, they cannot say that.
at best, relaxation of age can be given.
My lord,
He can be
relaxation
considered.
is that will not give me any benefit, because right now other candidates will come and their percentage of
But
mark.
if that advertisement, if it is actually found that it is contrary to the guidelines, then that cannot
My
be
lord,
sustained.
how it is contrary to the guidelines?
That-
If
that we
that
will
is
see.
so, my
Let
lord,
us see,
if
let us
that
see.
is so, why they have not done it till 2000 till your lordship passed the direction? Question is that.
May I be permitted to take your lordship to the page number 2 of my counter?
Counter.
Yes.
There may not in the first paragraph it is submitted. It starts with it submitted. The appointment that the petition was selected is incorrect, as no one has been selected on the basis of the notification. Advertisement date is 19/8/2009, my lord. In total, 8 candidates had applied for being considered for engagement of Anganwadi center. For the said center, objections were invited. During this period, 5 objections were received wherein objection was raised with regard to the validity of the service area on the ground that the same was defective as it did not conform the requirement of the guideline circular issued by the Women and Child Development Department, Government of Orissa. The said objections were taken into consideration after verifying the records. The VLCC, the competent committee, being satisfied, issued direction to the then CTPO Jagannath Prasad to resurvey the area and submit the report before the said committee. It is pertinent to mention here that the matter was discussed in selection committee held on 14/2/2011, 17/10/2012, 30 and 31/10/2012. The selection committee has decided to divide the area properly and again approve in BLCC meeting. After the approval in BLCC meeting, the advertisement was to be published for Bhusandapala B Anganwadi Center. The BLCC was fixed on 3/2/2015, 12/2/2015, but due to non-posting and in absence of Sub-Collector Bhanjanagar, the meeting could not be conducted. There is no related practice and other things. So, and thereafter, my lord.
My lord, where is the
Best-
objection? They have not.
Thereafter, my lord. After this annexure, based on the report of resurvey, the committee on 29/12/2015 approved the new survey area, which constituted more than 400 of population.
My lord, question is where is the objection? Right now, they have filed the counter affidavit stating therein that some objections were filed by the villagers regarding the selection of the service area, but they have not annexed the those objections.
That will be that I can.
If objections are there, my lord, let them also annex it.
Yes.
So how
Let
will
them
it help?
produce it.
No, how will it help you?
My
How will
lord,
it
my
The question is at the instance of the petitioner,
yes.
because the selection process has not actually been held. 8 candidates had applied. So all 8 had a right of consideration.
8 candidates
But at
applied.
that stage, it was found that the area was wrongly.
My lord, 8 candidates applied. Their certificates were verified, and only it was posted for declaration of the result. And that point of time, they didn't do anything. And even although I have come to this honorable court, and this honorable court has passed the order, and I have produced the same, why they have not stated or they have not cancelled the entire thing? Question, my lord, that my lord, there is, I think there is something else in between, because
Possible, it is possible.
yes,
Quite possible.
because they could have declared it then and there. Had there been any problem.
Sometimes local political
Yes,
things
yes.
also happen.
And they, out of court, I may mention, they wanted money. I could not.
Yeah, but there are 8 candidates. Why?
I am the highest, secured the highest.
Nobody has
rank.
been selected, man.
No,
Nobody has been offered with an
That,
appointment.
that also I have stated. Nobody has selected. Since you have not.
So you satisfy the court as regards
With respect to the objections, my lord. I will
yes,
produce them.
objections
Yes.
and the basis of publication of the first advertisement.
Yes, that also, my lord. And another thing, just now what I placed, my lord, that is also not given, my lord, what I found. The committee on 29/12/2015 approved the new service area. So that also we have not included, my lord, that also.
The original advertisement is of the year 2009.
9.
2009.
So 6 years down the line, you change it.
Yes.
So this is a very serious breach of the at least legitimate expectation, if not anything else. And normally she may not have a right. But then the government also has got no right to arbitrarily act like this. This is a pure arbitrary action.
I will produce that particular service area population and other
Not
things.
further arguments in part. This court would like to peruse, would like to know the basis of publication of basis of notification of the Anganwadi center setup. Busandapara B Anganwadi center.
B.
Busandapara B Anganwadi center. As per advertisement dated 19/8/2009. Stop. Further, this court would also like to peruse the so-called objections to the objections, if any, received by the authorities at the time of selection.
Yes.
Yes. List this matter. I am granting you 2 weeks.
Yes, ma'am.
14th August.
Item number 8.
Replies. My lord, if your lordship may kindly recollect that matter, I have been selected. I have given the preference to Puri. Shiksha Sahayako, appointment of Shiksha Sahayako. I was selected, but I have given appointment at Bhadra.
You are
And
to
right now, I am having
I was
the
directed
lordship.
to
whether vacancy is available in Puri or in any of the
One is available. At PI Act, I have this.
and in any of the other 5 districts.
state preference.
And it's in 24, 22 से 24.
What does it say?
My lord, the first page, my lord.
Hmm.
The subsequent pages are actually the reports which we received, my lord. As per the report submitted by the DEO cum DPCs of the concerned district, the vacancies against the advertisement dated 11/9/2014 and corrigendum dated 9/2016 with respect to SC candidate for the district Khordha and Puri were completely filled up.
But at PI Act shows one post
Really?
like that. Okay. Post say Anganwadi, but Kalyani Shakti, so and so, so and so. Sorry, कौन शिक्षा
Yes, sir.
sorry, वो ता पूर्वटा को
Teacher working in position vacant post like that.
हाँ, हम तो शिक्षा से तो टीचर नहीं है कौन.
So teacher को, my lord, I cannot exactly reconcile the two sentences, my lord, because there was a direction to me to
As directed
get
by the
this
State
separation.
Council has produced a letter dated 22/7/2024 of the State Project Director, Prosepa, addressed to the Additional Government Advocate, stating that there is presently no vacancy.
My lord, with respect to Khordha and
Ah,
Puri, all the
vacancy.
posts are filled up. With respect to the other 3 preferred district, my lord, that is Bhadra, Ganjam and
So
Korapur.
there is no vacancy. There is no vacancy. That there is no vacancy in the concerned districts as at present.
Yes, ma'am.
Mrs. Jana, surprisingly, 22 तारीख को.
সেটাকে with
Surprisingly,
teacher-
no, this is from a different office. Surprisingly, Mrs. Sujata Jena, General Counsel for the petitioner, produces copy of letter dated 22/7/2024 of the CRCC Kotho Kusanga cluster Nimapada, wherein tinta vacancies,
Again,
wherein 3 vacancies, wherein it is stated that there are 3 vacancies. in the
My lord,
Puri
I
district.
think, I think, my lord, I am permitted to clarify only after going through the records. Your lordship has specifically asked me to get the vacancy status with respect to SC category. And your RTI information, I don't think that is with respect to SC category.
There are the post vacant. That is also to, let me.
Oh, I can collect that.
Learned State Council shall take instructions with regard to this apparent discrepancy.
Yes.
Does this matter? Discrepancy in information. Does this matter on 7th August? Item number 9.
Mayor, please.
Yes.
Can I have a glance to the last order? I would have given a last chance to the state to take instruction because
Without any statement given by the lady supervisor Damayanti Jana referred to by the subordinate. Yes.
In
I
fact,
think, my lord, should be.
Yes. Record. Yes, Mr. Das.
there is no ground on which she can be accommodated or her.
No, the last my order was
Yes,
that because you could not trace out any statement of the lady supervisor, Damayanti Jana, which has been referred to by the sub collector
in the inquiry.
in the inquiry report. So where from did he get that statement? And that statement forms the basis of everything.
Damayanti Janna, she had made one application that the copy of which I have got, if your lordship wants.
Is there any statement?
Yes, she has said about her.
Good statement.
Yes.
Yes, it is.
Paridarshika.
Because in the we are referring to the file
Yes.
which you are ready with. But in that file, there was no such statement. Last time we did not find any.
In fact, no such application having been filed to her, that is not available at all. That is what the CDPO had on the other day said. He had said, in inviting a reference to the letter which was sent from this office, to the letter on the subject cited of, I am to bring to your kind notice that Srimati Gayatri Meher, Anganwadi worker, Burlia
Chikun.
4, was on unauthorized absence since 6/10/2018. She has not submitted any leave application to this office for that period. She has also not submitted any explanation in respect to letters issued to her by this office. Letter number he has given 22nd October 2018, 2/2/2019, 12/3/2019. So the original record relating to the unauthorized absence and explanation thereof is not available in this office.
This is what
She had said.
And for the ground of have a
Whatever
baby, I have been.
whatever was available with the CDPO, she has submitted. If your lordship wants, I can make a copy and submit the same.
You can close the matter. Give the file. Hearing concluded.
Whatever has been supplied to us.
Hearing concluded. Judgment reserved. The original file produced by the. You have the original file.
Not file, she has given certain photocopies of whatever was available. Let me call for the whatever was the original with her.
All right. Call for the original. We'll take it up next week then. Then State Council is directed to produce the original file along with the documents, the copies of which.
In respect of the petitioner, whatever is available with the CDPO.
State Council is directed to produce the original file and all documents relating to the disengagement of the petitioner.
Last chance, Madam.
In this matter next week, it is made clear that no further adjournment shall be done.
Next week, Friday.
All right, Friday call. क्या date होची? 2 तारीख.
Friday, 2nd August.
2nd August.
Item number 11,
तो इसी का ही इसका ऑर्डर से आरएस आइए
For the respondents, my learned senior Mr. Bhuya, he's badly placed and will not be available till 25th. The matter may be taken up next week. The interim order is there in favor of the appellant. Same may be continued and it may
therefore adjournment is made on behalf of Sri Vivekananda Bhuya, learned counsel for the respondent. Place this matter. On 21st August? On 21st August, interim order to continue.
much obliged.
I do not 12. Paso. I do not 13.
I will plead your caution.
12. 12. Let us pass it over because the petitioner is not there. Pass it over for some time, then we will see. Can pass it over. Yes, I do not 13.
I will plead your lordship.
Next week also.
All right. None appears for the petitioner. Learned counsel for the opposite parties is present. Place this matter next week. Yes, Mr. Mishra, what is this?
But the petitioner to any,
One pass over your lordship.
sir, not today.
Who's appeal?
Tomorrow.
Pass over your lordship.
Who is
For the opposite party.
Why pass over?
Learned senior Prafullo Kumar.
But he has been appointed against
Against the
me after my
termination vacancy.
termination. That will not on the last occasion say that he has nothing to do.
I am
Yes.
against the termination vacancy, your lordship.
And meanwhile, I have also retired. For consideration is
Yes.
governing body is the real
Mr. Sharma was appealing.
opposite party.
Yeah, Sharma has said that brief has been taken away. The notice was again issued.
Ah.
Oh, Mr. Ankit Mahathi, where is Mr. Ankit Mahathi? Who's? Again, he has appeared. Mr. Sharma has appeared.
Perhaps again some has appeared.
Yes, we'll call it tomorrow then.
Tomorrow.
As requested on behalf of Sri PK Ratha, is this matter tomorrow. I do not 14. So I do not 15. Is that adjourn go to mention goal for adjournment.
15, he had made a prayer for adjournment, but your lordship,
No, I said let me see the
Pass
brief.
over.
This is a 2011 matter.
your lordship had said it should be passed over.
Okay. Pass over. Pass over. Item 16. Item 16.
14 no instruction.
Item 16.
14.
Item 14, no instruction disposed of. Item 16. Pass over. Item 17. 17.
17 I am for OP, your lordship.
Okay, ना आते देखिए. पास ओवर ही था वो देखिए.
Next week.
पास ओवर हो देखिए.
Tomorrow no I have difficulty ଅଛି. Tomorrow I will.
All right, tomorrow. None appears with the petitioner. Is this matter tomorrow? Item number 18. Item 18.
I am for the petitioner. Your my lord, see the others. Mr.
Yes.
Swai is appearing for the
For IIT.
Union of India. But a very small point, my lord, in a due process of.
Nobody is there for Mr. Fine. He is the answering opposite party.
Yes.
We will take it up again tomorrow then. Tomorrow देखिए आपको. Sri Lanka Land Council for the petitioner is present. None appears for the opposite parties. Raise this matter tomorrow. Item 9. You can please inform him also. He may have missed the list.
May I please your lordship? My lord, in this writ application, the petitioner challenges the order of disengagement from the post of Gram Rojugar Sevak under Annexure 1, my lord. My lord, the petitioner was joined at JRS in the year 2016. Thereafter, my lord, his work, a GRS was appreciated and letter certificates were granted. Thereafter, a so-called notice was issued, my lord.
Mr. Nanda, this is an appellable order.
My lord, at that time it was not applicable under 13th or similar writ petitions have been remanded, my lord. Your lord, because he is continuing by virtue of the interim order of this court. Your lordship may kindly see, this is the order passed by your lordship in 7-8 writ applications. That opportunity for hearing was not granted to the petitioner. They are continuing. Therefore, the collector should relook at the matter.
So this is prior to those guidelines.
My lord.
Comprehensive guidelines.
13 guideline, my lord. It was this guideline, my lord. Your lordship has referred to this guideline.
Comprehensive guidelines, no?
Therefore, at that time, at that point of time, it was entertained, my lord, and
Yes.
it was violation of natural justice. Your lordship has been pleased to hold.
So here the matter was remitted to the collector to
In those
consider it
cases.
afresh after granting him opportunity of hearing and after calling for the performance report from the BDO. Same order we can pass here,
Yes.
and only the facts have to be.
My lord, at
Mention.
Clark 10, my lord, the BDO has also given the certificate that he is continuing, my lord. Clark 10.
That's all right, that's all right. We'll say it is covered by this.
My lord.
The petitioner has approached this court with the following prayer. In course of hearing, it is stated by both parties that the matter is covered by judgment of this court passed in WPC number 17746 of 2014. In as much as the impugned order of disengagement in the said case was set aside, was quashed, and the matter was remitted. No, it was quashed on the ground of non-compliance of the principles of natural justice. So accordingly, the matter was remitted to the collector Balangir to consider the explanation submitted by the petitioner and to pass a reasoned order after granting an opportunity of personal hearing to the petitioner. Stop. In the instant case, the impugned order dated 4/12/2020 passed by the collector does not mention anything as regards grant of personal hearing to the petitioner before disengaging him. Anything you want to say? No. Therefore, following the ratio laid down in the case of Uddhava Munna Supra, the impugned order is quashed. The matter is remitted to the collector Balangir.
Let your lordship may say that by virtue of interim order, he is continuing, my lord.
And
And the BDO has also granted certificate to that effect.
be it noted that because of interim order passed by this court on 18/12/2020, the petitioner is continuing as GRS despite passing of the impugned order. Stop. The BDO,
Flag 10, my lord. Flag 10.
the BDO
BDO listing, my lord.
has granted a certificate in this regard on 13/3/2024.
Great, my lord. But now he is attached to the block, my lord. Lusinga block. My lord. Grateful, my lord.
I do not 20.
In this matter, your lordship, the petitioner is challenging the order dated 22/7/2021, your lordship. Your lordship, kindly have a glance to it.
Yes, what are you challenging?
Kindly have a glance to page 20.
Anganwadi helper under Kapaleshwar, second, Anganwadi center. Yes,
Page 22.
you file your counter.
No, it could not be filed because it
Counter
has,
from the OP number 4, my lord. You have filed it,
no,
my lord. No, here, they has filed. You have not filed.
no.
Are you required to file a counter in this case?
In fact, the order impugned,
22 is the criteria, your lordship. Kindly have it.
Yes, yes.
I have tried to obtain the instructions, it having not been obtained.
No, since the ground of fraud was taken,
Yes,
and on such ground, her selection was set aside. I think you may have to file a counter in this case. It's a question of fraud. So let them justify.
Eligibility criteria रे there is no, they have not মানে certificate দেবার কিছু provision ই নাই eligibility criteria রে जो 5টা পয়েন্ট আছে সার্টিফিকেট র কিছু নাই তো ମୁଁ সার্টিফিকেট কাহিকি দেবি thereafter your lordship will, if a lordship will go to page 11 altogether I got 28 votes and the opposite party number 4 got only 8 votes. This is not a, this is on the basis of selection basis I have been selected.
Now, I have filed a counter, my lord. In that, my lord, I have mentioned that the age of the petitioner is more than 42 years at the time of appointment. So as per the notification, the age should be within 42 years. So I have obtained the RTI record and filed a counter. Her age is more than 45 at that time, my lord, when she was appointed.
And you let the state file a counter.
I have in my rejoinder I have given my date of birth.
Yeah, that's all right. Let the state file a counter. After hearing the counsel for the parties for some time, this court feels that the counter by the state is necessary. Place this matter
21st August.
on 21st August. Counter by the state shall be filed in the meantime positively.
Item 21.
OP4 may serve a copy of his counter.
Opposite party, counter filed by the opposite party number 4 be served upon land state council also. Yes.
Item 21, my lord. When notice was issued, and since I am challenging the selection, my lord, an interim order was there. So in spite of that, since appointment order was issued, I filed an amendment. Annex 9, my lord, page 12, the appointment also was issued.
In spite of an interim order.
What has happened, my lord? In fact, by the time interim order was passed, no appointment order was passed. I challenged the selection, I filed it application. But subsequently, they issued an appointment order giving a date of 7/12, my lord.
According to you, they have antedated it.
Antedated, but my lord, since they have given 7/12, I filed an application.
All right. Learned counsel with the petitioner files an application in court
Copy, sir.
with prayer for amendment of the writ application. Yes, you want to file any objection or?
Amendment? Oh, no.
It is submitted that after filing of the writ application, certain developments have occurred in as much as the opposite party number 6,
My lord.
opposite party number 5 has been favored with an order of appointment despite an interim order passed by this court in the present writ application. Stop. The petitioner wants to bring these facts on record. Stop. Now, State Council has no serious objection to the petition for amendment being allowed. Stop. The considering the above, the IE is allowed. Consolidated writ application be filed Within a week?
500.
Within a week? Let's this matter
Within 21st August.
on 21st August. IAB registered you the correct.
Item 22. May here is a case for that selection of a data entry operator from among the GRS. So may take a look to page 26.
Yes.
Page 26. There it is a recommendation made. My name is in serial 14.
Yes.
So as per the rule below, the if who has completed 5 years of continuous service, he is entitled to be promoted to this post. So my service is it is written there. I joined 29/12/2011 and to 23 to 2018. It was my continuous service. In 23 on the 23/2018, I was suspended. My service was terminated. So that I challenged before my lord. Then that was quashed. So then I reinstated in service. Then that starts from 23 to 18 to 16. Then as on date, I am continuing. So before suspension, I have completed more than 6 years. So now they say the continuous service, even either way, I have completed the service. Even your lordship may see in that years of service rendered, first 6 years, 1 month, 25 days.
Could where are you reading from?
Page 26.
Pardon?
Where are you reading from?
In that page 26.
খালি ডেটটা লেখা আছে
মানে তারপর সে ইয়ার্স লেখি কেতে মন্থ
আচ্ছা এরপর লেখা আছে
হ্যাঁ
6 years 1 month 25 days
তারপর 5 ବର୍ଷ 9 ମାସ 23 ଦିନ so ମାନେ either way it is more than 5 years and
no disengagement period is 5 years 9 months 23 days
yes
initially 6 years 1 month 25 days disengagement 5 years 9 months 23 days then you approach this court and your disengagement was set aside similar matter today I have disposed of similar matter in the morning
Yes,
I think
yes.
Mr. Patnaik was there same matter exactly same matter but there I directed have you been considered or you not been considered at all
I have been in the zone of selection
no thereafter have you been rejected has your application been rejected
not rejected exactly
what in the other case I think Mr. Nanda was appearing who was appearing in that matter oh Mr. Jagabandhu Sahu was appearing so he had approached this court I quoted the order of this court directing reinstatement and I asked the collector to consider it that's all
In view of the rules.
reinstatement
Reinstatement
I got it yes
so that is the only thing that can be done
only that can be
where is that order the High Court order
ମୁଁ ସେଟା ଜାଣିନି
ଅଛି ନା আপনার annexure 7 কোন করছেন
I'm judgment.
ও মিস্টার মাহাতি
Page
this
number
is a
29.
complete judgment has been passed by
29.
the quoted bench of this court
Yes.
this court hereby quashes the impugned order of disengagement dated 23
Don't let.
সেটা আপনার ফেভার আপনি সেটা কইবেনি so I will direct the collector to consider this aspect isn't it what do you say same order has been passed today morning the
Also
petitioner
this.
again
In the other case, your lordship also so directed.
the petitioner
চারটা পোস্ট ভ্যাকেন্ট আছে
64.
the petitioner was working
Post vacant.
where is your that document which you are showing
Page 26
page 26 no? Yes. The petitioner was engaged as Gram Rozgar Sevak. କୋଉ ଜାଗାର
ସେଟା ଏବେ ଦାରିଙ୍ଗବାଡିରେ ଅଛି
ସେତେବେଳେ ଯେତେବେଳେ initially join କରିଥିଲେ
ତୁମୁଡି ବନ୍ଧା.
ତୁମୁଡି ବନ୍ଧ
କନ୍ବା
ତୁମୁଡି ବନ୍ଧ ଗ୍ରାମ ପଞ୍ଚାୟତ in the district of Kandhamal with effect from on 29/12/2011 stop he was disengaged from service he was disengaged as GRS on 23/2/2018. Challenging such disengagement, he approached this court in WPC number 10286 of 2020. By judgment passed on 24/8/2023, the coordinate bench of this court held that the order of disengagement was illegal, and accordingly quashed the same inter alia, observing as follows. Para 36 ta quote kar debe. It is submitted by Sri Mahanti, learned counsel for the petitioner, that even though the petitioner has completed 5 years of service as GRS, even prior to the issuance of the illegal order of disengagement, this case has not been considered for absorption as accountant cum data entry operator on regular basis as per Odisha rule as per Odisha accountant cum data entry operator within bracket
Odisha accountant,
method of recruitment
cum DEO.
and conditions of service
Method
rules
of recruitment and
2024.
conditions also.
2024. Stop. This court, however, observes that though an order has been issued on 15/3/2024 regarding absorption of as many as 120 Gram Rozgar Sevaks as accountant cum data entry operators, there is no order specifically rejecting the case of the petitioner. Koi
already
ଆପଣ ଶୁଣୁନାହାନ୍ତି ମୁଁ କଣ କହିଲି? There is no specific order rejecting the claim of the petitioner for such absorption. Stop. Since there is proof of the petitioner having rendered 5 years of continuous service, and his order of disengagement was quashed by this court, the writ application is disposed of, directing the collector directing the collector Kandhamala to consider the case of the petitioner for absorption, taking note of the observations made in this order. The collector shall act upon a certified copy of this order to be produced by the petitioner and take a decision thereon within 4 weeks thereafter. Yes. So that's all. Writ application is disposed of accordingly.
I don't know, don't that really say 64, that's the indicate.
It is submitted by Sri Mahanti that as many as
64 vacancies.
64 vacancies still exist in the Kandhamala district. In Kandhamala district, in the post of accountant cum data entry operator, and therefore the petitioner can be easily considered for such post. Yes.
Okay.
Item 23.
In this matrimonial, I am appearing for the opposite party. Here the prayer has been made to transfer.
For the petitioner. You are there, okay.
Yes, section 9 prayer for transfer of the section 9 application from Keuzat. But in meantime, there is already conciliation and both the parties are residing together.
So it has
On
become
last occasion, I had sought time to take instructions, my lord.
yes.
I had sent a postal letter and also I have tried to contact her phone, but I could not get any instructions. So if the prayer of my learned senior is allowed,
Yes.
so if there is liberty to
Yes.
approach this Hon'Ble court if any cause of action.
Yes. Sri Panigrahi, learned counsel appearing for the opposite party, again submits that the parties are residing happily and therefore the transfer application has become infructuous. Learned counsel for the petitioner submits that he has not received instructions from his client despite several attempts. Stop. Since this is a case of the year 2017, I am not inclined to keep the matter pending any further. The transfer application is therefore disposed of as infructuous. It shall be open to the petitioner to seek revival of this order if any cause of action survives.
Publish.
Item 24. Transfer of certificates from the family court Bhubaneswar to family judge Jaipur Matter.
The petitioner is a lady, opposite party is also a lady.
No, no, he is a husband one.
You know,
Tanuj Kumar Bell.
Tanuja will put.
May your lordship kindly see annexure.
FIR ଦେଇଛନ୍ତି?
FIR was lodged by the present petitioner before the Jankia police station under the jurisdiction of Khurda, SDGM Khurda, which was pending at page, your lordship kindly see 1cc number 174 of 2018. Thereafter, while I am filing the CP case in that jurisdiction, and your lordship kindly see the cost title. He is staying at PS Jankia district Khurda.
At present, Dr.
At present, subsequently wants to transfer my lord.
But will the parties agree for mediation? What do you say? ହବନି?
ଆମେ ରେଡି ଅଛୁ ନବା ପାଇଁ।
ସେ ଫାଇଲ କରୁଛି।
ହଁ, ସେ 13% ଫାଇଲ କରିକି ତ ସେ ରେଡି ଅଛି ନା, 13 ପିଟିସନ ରେ ହିଁ ତ ହବ, ଆଉ କୋଉଥିରେ ହବ? To agree for mediation, I can send it to mediation. Either High Court Mediation Center or Khurda, wherever. ଖୋର୍ଦ୍ଧାରେ କରିହବ, କିଛି ଅସୁବିଧା ନାହିଁ।
I take instruction.
Instruction ନେବେ? 2019 matter, what instruction? What do you say? What instruction? Yes.
Yes. For that.
In course of hearing, it is stated at the bar that the nature of the dispute is such as can be nature of the dispute is such that an attempt can be made to resolve the same amicably through the process of mediation. In such view of the matter, let the records be placed before the chairman TLSC Khurda, who shall appoint a mediator from the panel. Stop. The parties are directed to act upon receipt of notice from the mediator so appointed and to render full cooperation in the mediation process.
At Khurda.
Khurda to କହିଲି ଆଉ
Right.
ତାପରେ release this matter ମାସେ ପରେ କର
25th September.
25th September. Is there any interim order?
Yes. Interim.
No, interim order to continue. To the next.
Item 25.
Lordship, on the behalf of Mr. Balaram Naik, contacting counsel for the opposite party, FRI for 2 weeks time. Lordship.
2 weeks time.
Yes.
This is what you say.
I have sought for transfer of a
2 weeks now, I will keep it to next week. 2 weeks now. Prayer for adjournment is made on behalf of the counsel for opposite party. List this matter next week.
interim order.
Interim order to continue.
Item 26.
Your lordship, on the last occasion, directed to local jurisdiction of the police to intimate the matter. The
Notice has been served. State counsel,
Yes, somebody has appeared, I find.
Mr. B.K.
So
Padi.
I have not received no instructions from the police. But it shows that Sushant Kumar Pradhan.
Okay.
26.
29 months.
Learned State Council submits that he has no instructions regarding service of notice on the opposite party.
I am committing 28.
28 no, এটা
नहीं बर्तमान এটা কেতে
26.
26
I am sorry.
26 এর কোন আছে দেখলে
The 26 I'm open 9.
26 এর কি অ্যাপিয়ার করে নাকি
No.
Yes.
Let
see
my
your-
learned friend serve a copy, I will see.
No, he has already served.
Well, sir.
He's already served.
How does he do it?
No, আমার খালি ইনস্ট্রাকশন দেওয়া পড়ো
Yeah.
I'll call it tomorrow.
Yes.
Tomorrow, so that
I would request my friend to serve another copy because I
serve a copy.
have not.
Let's this matter tomorrow.
Item 27.
Petitioner, Your Lordship, I am appearing on behalf of the petitioner, Your Lordship. The matter was pending, but in the meantime, Your Lordship, the family court has set me ex parte and has the matter judgment has been passed, Your Lordship.
You filed any petition for recording that
Yes,
order?
no, Your Lordship, I have not filed a petition for
So this
recording.
has become infructuous,
Yes, Your Lordship.
dismissed as infructuous.
But the matter was pending, Your Lordship. Notice was issued. The time petition was filed accordingly, and it was well within the knowledge of the learned judge, family court, Your Lordship. In spite of that, he has passed an order for.
Divorce has been allowed. Divorce has been allowed.
Sorry, all right.
Item 28.
Yes, Lordship.
May I please, Your Lordship? I am appearing from the opposite party, my lord.
You are for the petitioner.
I am for the petition, my lord. Thus, in this case, filed a petition to transfer the CP number 84 of 2021 that has been filed by the present opposite party, husband Manoj, for grant of divorce under section 13(1) of the Hindu Marriage Act from Jagatsinghpur to Cuttack, Manoj.
Any chance of settlement?
Manoj, as of now, there is none, Manoj.
How?
But I have filed another petition that is under section 9 that is also pending before the same family court, Manoj.
So if you have filed a petition for section 9, it means you want to live with your
I
husband.
want to live. I want to live.
You want to live with your husband. So how can you say that there is no chance of settlement?
There is, my lord, but from the side of the husband, my lord, we are not getting any positive signs.
You don't have to get.
Your Honor, directed to mediation.
All right. At Cuttack High Court mediation.
My
center.
lord, much obliged.
Mediation Center High Court. You are directed to act after receiving notice from the
Right.
mediator. Place this matter on 14th August. Lama karo.
4th September.
4th September.
Item 29 also same.
No, is there any interim order?
Interim order, my lord.
What was stay?
Stay, my lord.
All right, interim order to continue with the next date.
Both the matter.
Item 29, same.
Same, my lord.
Same.
Item 30.
Much obliged.
Item 30.
Transfer of application from Raidangpur to Raurkela, madam. Yeah. In the meantime, what happened, madam? Last time, I directed to transfer the matter to the
After
body.
that, I had taken time.
In the meantime, what the petition of son of as a transfer application has been initiated due to illness of his mother, my lord. As she is staying at Bonnie at 11 years, my lord. On that ground, transfer application initiated, my lord. And in the end of this month, transfer she will transfer to Raurkela, my lord. And his mother is suffering from paralysis, my lord. I pray, my lord, transfer to Raurkela and he will appear virtual, my lord.
Because I had filed the matrimonial suit at Raidangpur. The wife, she has come up, Your Lordship, to transfer that matrimonial suit from Raidangpur to Raurkela. So last occasion, I had given a proposal and made a submission before Lordship to middle area, Keonjhar area. That respect, twice he had taken time. Again, let it the matter be referred to the conciliations. Let them sit at once at least.
And there is no chance of reunion. He is married, my lord. In the meantime, married.
Yeah.
That
more knowledge.
494. There is no chance of reunion.
Well, you appear virtually.
The
petitioner wife seeks transfer of matrimonial suit number 204 of 2021 pending in the Court of Learned Civil Judge, Senior Division, Raidangpur to the Court of the Judge, Family Court, Raurkela.
Okay.
Therefore, transfer has been made on the ground that the petitioner is residing at Bonai.
No, Raurkela, my lord.
She is residing at Raurkela. And Raidangpur is at a distance of 400 kilometers.
Yes, ma'am.
Is at a distance of nearly 400 kilometers. from Rourkela. As such, it would be inconvenient on her part to travel to Raidangpur
Raidampur.
to attend the court on the dates fixed. Learned counsel for the opposite party husband has opposed the prayer for transfer on the ground that the opposite party is working at Raidangpur.
I am working as a junior engineer in Karanji.
Is working in Karanjia, and therefore it would be difficult for him to travel to Rourkela to attend the court on the dates fixed in the case. Considering the relative inconvenience of the parties, this court is of the view that it would be more inconvenient for the wife to travel from Rourkela to Raidangpur. As such, I am inclined to allow the prayer for transfer. It is directed that such and such. Last karibe, virtual mode, personal attendance will not be insisted upon unless absolutely necessary.
Okay.
Item 33. 32 ta कौन रहेगी? 31, 32 sir adjourn session.
Sir, I am appearing for this.
As per petition, claimant now residing at Cuttack, and he is on the treatment at a regional spine center Cuttack, and he was doing labor work. As he is now residing at Cuttack, he want to transfer his case from district judge Borgot to.
Who is appearing?
Sir, I am appearing for the opposite party number 2.
Opposite party number 2. Anybody for opposite party number 1? Mr. Ramesh Chandra Sahu appear for opposite party number 1. Pramod Kumar Bajar appear for opposite party number 2. All right.
Sir, I am for OP2.
OP2.
Ramesh Chandra Sahu for OP2.
OP1 लिखा ही चाहिए.
OP1 ଆଉ ଜଣେ ବାବୁ appear କରୁଛନ୍ତି. ପ୍ରମୋଦ के
ଆପଣ ନାଟା ରମେଶ ଚନ୍ଦ୍ର ସାହୁ ଲେଖା ହେଇଛି OP number 1 ବୋଲି.
wrongly sir ଲେଖା ହେଇଛି. I am for the insurer.
Yes, what do you say that let the case be transferred?
In fact, in an application under section 166, the convenience of the claimant is paramount consideration. So virtually I have not so much objection provided the person.
Sir, you are not audible.
Sir, am I audible now?
Not much, but so what have you got to say? This is a LACT case.
Yes, ma'am. Provided he is staying at Cuttack, this address given in the cost title is a very vague one. The address given in the cost title of the application.
He wants it to be he wants it to be transferred from Borgot to Cuttack. It is at his risk. If he is not residing at Cuttack, it will be his problem.
Yes, no objection, ma'am.
All right. The petitioner seeks transfer of MSc case number 7 of 2021 pending in the court of learned district judge come MSCT Borgod to the MSCT Cuttack हुए नहीं है.
First additional district judge MSCT.
MSCT Cuttack, district judge Cuttack is the filing court. He doesn't hear MSCTs. He transfers it to first and second ADJ or to the second MSCT.
That is first additional civil judge, sir.
First additional
First additional civil judge.
He wants the to Cuttack will लिख दो Cuttack लिख दो हमें first ADJ कर दो. It is submitted that the petitioner is residing at Cuttack and working as a daily laborer. As such, it would be difficult on his part to travel to Borgod to appear in the case whenever required. Learned counsel appearing for the opposite parties has no serious objection to the prayer for transfer. In such view of the matter, the transfer application is allowed. It is directed that so and so. MSc case number pending in the court of shall be transferred to the court of first additional district judge Cuttack.
Come MSCT.
Item 34.
May I please, Lord, sir?
The petition is the wife, my lord, seeking a direction to transfer the divorce petition filed by the husband from family court, Puri to the family court, Khordha. Yes, what do you say?
In the meantime, that CP has already been disposed of.
Stay not lagi. Time puts. Permission पहले adjourn नहीं थी कौन नहीं थी देखिए Did you not file time petition on that day? Expertise. So you did not obviously appear probably. Respondent was set ex parte on 24/2024. Yes. So probably you did not file any application to set aside the ex parte order. No worry. Infructuous or not? Yes. Since it is submitted that the case in the court below has in the meantime been disposed of, the application for transfer is rendered infructuous and is disposed of as such.
Item 35. May I please? In this case, my lord, last occasion notice was issued, but that has been returned unserved with a noting that notice returned undelivered from sole opposite party with a postal report, door locked. So
Get a copy of the transfer application. Be served upon Land and State Council, who shall cause the notice, cause it to be served upon the opposite party through the IAC of opposite party address to the Khantu.
Baleshwar Town PS.
Through the IAC of Baleshwar Town PS, indicating that the matter shall be taken up for hearing on 21st August. 21st August. List this matter on 21st August.
Item 36.
My lord, last occasion, my lord, issue notice to the opposite party, my lord. It's the wife of the opposite party. Notice I see. Somebody is appearing. No. Which your office note calling. Service no of notice completed. Office note indicates that notice on the opposite party has been served. There is, however, no appearance from the side of the opposite party for which the transfer application is taken up for hearing. You wanted to be transferred from which place to which place? My lord, Jaipur, no Barampur. For the huh? Allowed. Obliged. Yeah, we'll do formal. Item 37.
Item 37, the present petitioner is the wife of the opposite party, number 2, opposite party, and seeking
already appeared, my lord. File भी ना
आज फाइल क्वेश्चन
नहीं फाइल कर दी थी
PSK Dwivedi, advocate and associates have entered appearance for the opposite party by filing Wakalathrama in court.
ना आगुर फाइल करते रजिस्टर
Hello. Their names to be reflected in the cause list. Settlement abo.
Sir, may allow their prayer, my lord, for transfer with a direction to dispose this period. With a certain period may be disposed of.
Okay.
And if necessary, Suarez may afford the opportunity to appear through virtual.
Appear कर दो, मैंने allow कर दो, virtual mode कर दो. Further 24 matter में करिए. Expedite करिए पे करिए. They are under a lot of pressure. No. You put I go to no expeditious.
खाली what?
No. The target rate say that their case will be segregated as target, and the presiding officer will have to submit an explanation to the court.
Yes. No. But only indicate that virtual opportunity to if necessary.
Sit touch.
Yes.
Item 38.
And after the notice has been issued to the opposite party, my lord. Petition is the wife, my lord. In transfer of CPK.
Nobody has appeared. Let us see. Service of notice completed. Office note indicates that notice on the opposite party was served. There is, however, no appearance from the side of the opposite party for which the transfer application is taken up for hearing.
Baleswar to Baripata.
My lord.
Allow kore debe. Allow.
Item 39.
Yes, Mr. Lanka. The order should be corrected accordingly.
Item number 40.
Change of none.
Extension time of surrender, lordship.
Extension of time for surrender.
Yes, last
Extension of interim bail.
Yes, lordship. Last occasion, lordship directed to release on bail, interim bail for the period of 4 months, lordship. And
4 months ହେଇଗଲାଣି.
नहीं 2 तारीख दिन आएगा.
Why do you want extension?
Extension 1 month, lordship. The date of surrender.
Date of surrender. All right. 1 month. Huh?
Item 41.
Pass over.
41.
Arrange 1 pair, lordship.
Yes.
Arrange 1 pair, 2 accused person in the another case, lordship. 41, lordship.
41 कौन होगा?
Arrange 1 pair, the 2 accused. The lordship.
Same.
Yes, lordship.
All right. Same order.
Okay.
Item 42.
Pass over.
Item number 43.
43 praying for 1 week after.
Notice has been issued in this case.
Sort of. My power is not there. Mr. Satpathy is going to add.
All right. 1 week after.
Fine.
That's
Okay.
good.
Item 44.
May I please, Lord?
It's case, your lordship, last occasion, the deposition copy has been called for.
Status report.
When I, your lordship, on the status report. Here, all total, your lordship.
Out of 69, 3 witnesses have already been examined.
Yes, I have been posted in 2.5 years, your lordship. 3 years, 7 months.
The court below has submitted a report stating that 3 out of 69 charge sheet witnesses have been examined so far. Yes. And the deposition, copies of deposition, yes. 1, 2, 3, 3 जनों को पठाई Yes.
That is not with me, your lordship, that it is there, your lordship.
What? The deposition copy?
Deposition part is concerned.
Oh, yes, deposition is there. What is the...
My complicity of implication so far case is concerned, lordship.
Why is this an appeal? SCST?
Juvenile, lordship.
Oh, juvenile, oh, yes.
Juvenile, lordship. Here, what happened, some of the co-accused persons may release on bail. They are also active participants in the case is concerned. This case is initiated by 2 investigation agencies. First of all, General Police, then it is to CBI errors. In the General Police statement that I am one of the member of the unlawful assembly. But so far the CBI investigation concerned the one system, there is no whispering against me, lordship. Rather against they were whispering, they have been released on bail. So copy have also been filed in a separate memo that is filed, your lordship.
Mr. Jana, you do one thing, you go through the depositions so that it will be easier for you to.
No, nothing is there, lordship. There is nothing against me.
No, you've gone through.
It's so far 2 I has gone for you.
1, 2, 3.
So far last one is that there 2 has also been filed by earlier. April the 9th.
No, what is the allegation?
Here the case, your lordship, one video cameraman kidnapped, your lordship, by a lady. In associated some of the persons, including one Niranjan Sethi, your lordship.
Oh, that matter.
Yes, madam.
Yes.
That photographer.
Yes, madam.
And
Then
one Sarojini Settha, who is the caretaker of that ashram.
Sarojini Settha has not been.
No, she is
Has
the
not been
sole
examined,
witness and
lordship.
she has implicated all
And the
of them.
Sarojini Settha one assistant statement so far CBI part is concerned, she has also been never a single word against me, your lordship. No one assist one. But your lordship have glance, I am in custody in 2.5 years, lordship. 2 ବର୍ଷ 7 ମାସ ହେଇଗଲାଣି. 69 witnesses. ମାତ୍ର 3ଟା ଆଜ୍ଞା ଆ ଭିତରେ examination ହେଇଛନ୍ତି.
Kidnapping and murder. Kidnapping, murder, and thereafter burying the dead body.
The person they have been released on, they have been active participation. They kidnapped one Niranjan Sethi has been kidnapped, the part of the gang, your lordship. The person who has been identified as the person who is leading to discovery, he has been released on bail, your lordship. And another person who has also made arrangement, he has been released on bail.
Sarojini Settha ro yeta padhile.
Sorojan sort of CBI statement I may have put. Yes, madam. ମୁଁ ସରୋଜିନୀ ସିଟ ଏଲିଆସ ସୋନି ଆଜି ତା 27/3/2022 କ୍ରାଇମ ବ୍ରାଞ୍ଚ ଡିଏସପି ଶ୍ରୀମତୀ କଳ୍ପନା ସାହୁକୁ ମୋର ମୌଖିକ ବୟାନ ଏହିକି ଯେ ମୋର ଆର୍ଥିକ ପରିସ୍ଥିତି ଖରାପ ହେତୁ ଆମ ଗାଁର ବୈକୁଣ୍ଠ ଭାଇକୁ କହିଥିଲି ମୋ ପାଇଁ କେଉଁଠି ହେଲେ କାମ ଖୋଜିଦେବା ପାଇଁ। ବୈକୁଣ୍ଠ ଭାଇ ପ୍ରମୋଦ ବୋଲି ଜଣେ ଲୋକ ସହ କଥା ହେଇ ମୋ ପାଇଁ ଭୁବନେଶ୍ୱର ସୁନ୍ଦରପଦା ସ୍ଥିତ ଦୟାଲ ଆଶ୍ରମରେ ମାସିକ 4000 ଟଙ୍କା ଦରମାରେ ମୋ ପାଇଁ କାମ ଖୋଜି ଦେଇଥିଲେ। ମୁଁ ସେଇ ଆଶ୍ରମରେ 15/3/2021 ଦିନ ଯୋଗ ଦେଇଥିଲି ଓ ମୁଁ ମୋ ଛୋଟ ଛୁଆ ଯାହାର ବୟସ 4 ବର୍ଷ ସହିତ ଆଶ୍ରମ ରହିଲି। ଦୟାଲ ଆଶ୍ରମର ମାଲିକ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ ହି ଇଜ ଦ କିଙ୍ଗ ପିଅର ଲର୍ଡସିପ। ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ ମୋତେ ଆଶ୍ରମର ଉପର ମହଲାରେ ଗୋଟିଏ ରୁମରେ ରହିବାକୁ ଦେଇଥିଲେ ଓ ମୋତେ ଆଶ୍ରମର ରୋଷେଇ ଅତିଥି ମାନଙ୍କର ରେଜିଷ୍ଟ୍ରେସନ ନୀତିଦିନିଆ କାମରେ ନିଯୁକ୍ତି କଲେ। ଆଶ୍ରମର କାମ ବ୍ୟତୀତ ଶର୍ମିଷ୍ଠା ସେଠି ମ୍ୟାଡାମ ତାଙ୍କ ଘର ଓ ଅଫିସ କାମରେ ମଧ୍ୟ ମୋତେ ଲଗାନ୍ତି। ମୁଁ ଆଶ୍ରମରେ ଦୈନନ୍ଦିନ କାମ କରିବା ସମୟରେ ଆଶ୍ରମକୁ ବିଭିନ୍ନ ଲୋକ ଆସନ୍ତି। ସେମାନଙ୍କ ମଧ୍ୟରୁ କିଏ ଆଶ୍ରମକୁ ଯଦି ଦାନ କରନ୍ତି ସେମାନେ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମଙ୍କ ଅଫିସରେ ଯାଇ କଥା ହୁଅନ୍ତି। ମୁଁ କାମ କରୁଥିବା ସମୟରେ ଆଶ୍ରମକୁ ବିଭିନ୍ନ ଭଦ୍ରଲୋକମାନେ ଯଥା ନମ୍ରତା ଚୋଡା, ଗୌରୀ ମ୍ୟାଡାମ, ନିରଞ୍ଜନ ସେଠୀ ରିଲିଜନ ଇନ ଦିସ୍ କେସ୍ ଆସାମ ମିଲରସିପ, ଝୁନା ଦିଦି ଆଦି ଲୋକମାନେ ଆସନ୍ତି। ମୁଁ ନିରଞ୍ଜନ ସେଠୀ ସାରଙ୍କୁ ଆଶ୍ରମକୁ 3 ଥର ହେବ ଦେଖିଛି କିନ୍ତୁ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମଙ୍କୁ ସମ୍ପୂର୍ଣ୍ଣ ନ୍ୟୁଜ ବହୁତ ଥର ଦେଖିଛି। ମୁଁ ରହୁଥିବା ଆଶ୍ରମ ତଳେ ଦୁଇଟି ରୁମ ସେଥିରୁ ଗୋଟିଏରେ ଅଫିସ ଓ ଅନ୍ୟଟିରେ 2 ଜଣ ମହିଳା ବୃଦ୍ଧା ରହୁଥିଲେ। ଉପର ମହଲାର 3ଟି ରୁମ ସେଥିରୁ ଗୋଟିଏ ରୁମରେ ଆଶ୍ରମର ଜିନିଷ ରୁହେ, ଗୋଟିଏ ରୁମରେ ମଉସା ମାନେ ରୁହନ୍ତି ଓ ଅନ୍ୟ ରୁମରେ ମୁଁ ମୋ ଛୋଟ ଛୁଆ ସହିତ ରହୁଥିଲି। ଆଶ୍ରମରେ ଥିବା ଅଫିସରେ ଗୋଟିଏ ପାନାସୋନିକ ଟିଭି ଲାଗିଅଛି। ପ୍ରତ୍ୟେକ ଅଗଷ୍ଟ 15, ଜାନୁଆରୀ 26 ଓ ଅନ୍ୟ ଦିନରେ ଆଶ୍ରମକୁ ନମ୍ରତା ଚଡା ଓ ଅନ୍ୟ ମହିଳାମାନେ ଆସନ୍ତି। ତା 10/12/2022 ଦିନ ସମୟ ପ୍ରାୟ 10ଟା ବେଳେ ମାନସ ସ୍ୱାଇଁଙ୍କୁ ମାନସ ଡିସି ଜଏଣ୍ଟସି ମାନସ ସ୍ୱାଇଁଙ୍କୁ ମ୍ୟାଡାମ ତାଙ୍କ ସାଥିରେ ଆଣି ଆଶ୍ରମକୁ ଆସିଲେ ଓ ଉପର ରୁମରେ ମଉସାଙ୍କ ସହ ରହିବାକୁ କହିଲେ। ଆଶ୍ରମ ରହି ମାନସ ସ୍ୱାଇଁ ଅଫିସ କାମ କରେ। ତାପରଦିନ ମୋ ପାଖରେ ପଇସା ନଥିଲା ତେଣୁ ମୁଁ ଆମ ଗାଁକୁ ପଳେଇଗଲି ଓ 30/1/2022 କରି ପୁଣି ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ ଡାକିବାକୁ ଆଶ୍ରମକୁ ଆସିଲି। ମୁଁ ଆଶ୍ରମରେ ଦିନ ପ୍ରାୟ 2ଟାରୁ 2:30ରେ ପହଞ୍ଚିଲି। ମଉସାଙ୍କୁ ଖାଇବାକୁ ଦେଲି ଆଉ ପ୍ରାୟ 3ଟାରେ ସ୍କାଇ ଟାୱାରରେ ଥିବା ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମଙ୍କ ଘରକୁ ଗଲି। ସେଠି କେହି ନଥିଲେ, କେବଳ ତାଙ୍କ ଝିଆରୀ ଥିଲେ। ତାପରେ ମୁଁ ସମ୍ପୂର୍ଣ୍ଣ ନ୍ୟୁଜ ଅଫିସକୁ ଗଲି। ସେଠି ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମଙ୍କ ଭାଉଜ ଥିଲେ, ମାନସ ସ୍ୱାଇଁ କାମ କରୁଥିଲେ। ସମୟ ପ୍ରାୟ 4ଟା ପ୍ରାୟ ହେବ। ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ, ନିରଞ୍ଜନ ସେଠୀ ସାର୍ ଆଉ ଜଣେ ସାମ୍ବାଦିକ ତାଙ୍କ ନାମ ଅମୂଲ୍ୟ ଭାଇ ସମସ୍ତେ ମିଶି ମ୍ୟାଡାମଙ୍କ କାରରେ ଅଫିସକୁ ଆସିଲେ। ସେମାନେ ଆସିବା ପରେ ମୁଁ ଆଶ୍ରମକୁ ପଳେଇ ଆସିଲି। ସେଇଦିନ ରାତି ପ୍ରାୟ 7:30 ହେବ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ ମୋତେ ଫୋନ କରି ଜଣାଇଲେ ଯେ ଏଠି ଗୋଟିଏ ଝାମେଲା ହୋଇଯାଇଛି, ମାନସ ଯାଉଛି କବାଟ ଫିଟେଇବୁ ନାହିଁ। ସମୟ ପ୍ରାୟ 8ଟା ହେବ। ଶର୍ମିଷ୍ଠା ମାନେ ନିରଞ୍ଜନ ସେଠୀ ସାର୍ ଅମୂଲ୍ୟ ସମସ୍ତେ ମିଶି ମାନସକୁ ଆଣି ଆଶ୍ରମକୁ ଆଣିଲେ। ସମସ୍ତେ ମାନସକୁ ଉପର ରୁମକୁ ନେଇଗଲେ। ତାପରେ ନିରଞ୍ଜନ ସାର୍ ଗୋଟିଏ କ୍ୟାମେରା ଧରି ତଳକୁ ଆସିଲେ ଓ ତାଙ୍କ ପଛେ ଅମୂଲ୍ୟ ଓ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ ମଧ୍ୟ ମାନସକୁ ସାଥିରେ ଧରି ତଳକୁ ଆସିଲେ ଓ କାରରେ ପଳେଇଲେ। ତାପରେ ମୁଁ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମକୁ ଖାଇବାକୁ ପଚାରିଲି। ସେ କହିଲେ ମାନସ ନ ଆସିଲେ ନ ଆସୁ, ଆଶ୍ରମରେ ଚାବି ଫିଟେଇବୁ ନାହିଁ। ମାନସ ଭାଇ ରାତି ପ୍ରାୟ 9:15 ଆସିଲା, କଲିଂ ବେଲ ମାରିଲା, ମତେ ଡାକିଲା କିନ୍ତୁ ମୁଁ ଚାବି ଫିଟେଇଲି ନାହିଁ। ତାପରେ ମାନସ ପଳେଇଲା। ରାତି ପ୍ରାୟ 11ଟା ବେଳେ ମତେ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ କଲ କଲେ ଓ କହିଲେ ମାନସ ଏଠୁ ଖାଇବାକୁ ଯାଉଛି, କବାଟ ଫିଟା। ଯାହା କରିଛି ଭଗବାନ ତୋ କଥା ବୁଝିବେ। ତାପରେ ମୁଁ କବାଟ ଖୋଲିଲି। ମାନସ ଆଶ୍ରମକୁ ଆସି ତା ରୁମରେ ଶୋଇଲା। ତା ପରଦିନ 31/1/2022 ସକାଳ 9ଟା ହେବ। ମୁଁ ମାର୍କେଟକୁ ପନିପରିବା ଆଣିବାକୁ ଯାଇଥିଲି ଓ ଫେରିଲା ପରେ ଦେଖିଲି ମାନସ ଭାଇ ରୁମରେ ନାହିଁ। ମଉସା ପଚାରିଲି, ସେ କହିଲେ ସେ ଦେଖି ନାହାନ୍ତି। ତାପରେ ମ୍ୟାଡାମକୁ କଲ କରି କହିଲି ମାନସ ଆଶ୍ରମ ନାହିଁ। ମ୍ୟାଡାମ କହିଲେ ହଉ ସେ ଯାଉ, ନିରଞ୍ଜନ ସାର୍ ତାକୁ 2 ଦିନ ଟାଇମ ଦେଇଛନ୍ତି ମେମୋରି ଚିପ୍ ଆଣିବା ପାଇଁ। ତାପରେ କ୍ୟାମେରା ରଖି ଦେଇଛନ୍ତି। ସେ ମାନସ ଯିବ କୁଆଡେ? 2-3 ଦିନ ପରେ ପ୍ରାୟ 10ଟା ବେଳେ ମ୍ୟାଡାମ ମତେ ଓ ଘର ଓଳାଓଳି କରି ଓ କାର ଧୋଇବାକୁ ଡାକିବାକୁ ମୁଁ ଯାଇଥିଲି। ସେଇଠି କାମ କଲା ବେଳେ ମ୍ୟାଡାମ କାହା ସହିତ କଥା ହେଉଥିଲେ ଓ କହୁଥିଲେ ମାନସ ପାଖରେ ଚିପ୍ ଅଛି, ସେ ମତେ ଦେଉନାହିଁ। ସେତେବେଳେ ମ୍ୟାଡାମଙ୍କ ଭାଉଜ ମୁଁ ତାଙ୍କ ପାଖରେ ଥିଲୁ। ମ୍ୟାଡାମ କହିଲେ ରୁହ ମୁଁ ମାନସକୁ ଫୋନ କରୁଛି। ମ୍ୟାଡାମ ଫୋନ କଲେ, ସ୍ପିକର ଅନ୍ କରି ମାନସକୁ କଲ କଲେ କିନ୍ତୁ ମାନସ ଫୋନ ଉଠେଇଲା ନାହିଁ। 5 ମିନିଟ ପରେ ମାନସ ମ୍ୟାଡାମକୁ ଫୋନ କଲା। ମ୍ୟାଡାମ ତାଙ୍କ ଫୋନରେ ଲାଉଡ ସ୍ପିକର ଅନ୍ କରି କଥା ହେଲେ। କହିଲେ ମୋର ଜିନିଷ ତମ ଜିନିଷ ମୋ ପାଖରେ ଅଛି। ସେ କହିଲା ମୋ ପାଖରେ ଚିପ୍ ଅଛି କିନ୍ତୁ ମୋର 10,000 ଟଙ୍କା ଓ କ୍ୟାମେରା ଦେଲେ ମୁଁ ଦେଇଦେବି। ମ୍ୟାଡାମ କହିଲେ କେଉଁଠି କି ନେଇକି ଯିବି କହ। ତାପରେ ମାନସ କହିଲା ତୁମ ଉପରେ ଭରସା ନାହିଁ କି ବିଶ୍ୱାସ ନାହିଁ, ଅନ୍ୟ ଲୋକ ହାତରେ ପଠାଅ। ହଉ ହଉ କହି ମ୍ୟାଡାମ ଫୋନ ରଖିଦେଲେ। ତାପରେ କାହାକୁ ଗୋଟେ ଫୋନ କଲେ ଓ କହିଲେ ମାନସ ଏମିତି କହୁଛି, ମାନସ ସୁଟିଂ ଚାନ୍ଦବାଲରେ ଅଛି, ଲୋକ ଠିକ କର, ତାକୁ ଉଠେଇକି ଆଣିବା ଓ ଯାହା ପଇସା ଲାଗିବ ମୁଁ ଦେବି। ଏତିକି କଥା ହିଁ ଫୋନ ରଖିଦେଲେ। ଫୋନ ରଖିଦେଇ ମ୍ୟାଡାମ ମତେ ଓ ତାଙ୍କ ଭାଇଙ୍କୁ କହିଲେ ଦେଖୁନ କେମିତି କଥା ହଉଛି, ସେ ମୋର ଚିପ୍ ରଖିଛି ମତେ ଦେଉନି, ମାଗିଲା ଖୁଣି ମୋ ସହିତ ଖେଳୁଛି। ତା ପରଦିନ ପ୍ରାୟ 11ଟା ହେବ ମୁଁ ଆଶ୍ରମକୁ ଫେରି ଆସିଲି। ମୁଁ ଆଶ୍ରମକୁ ଆସିଲା ପରେ ତା 5/2/2022 ପର୍ଯ୍ୟନ୍ତ ମ୍ୟାଡାମ ଆଶ୍ରମକୁ ଆସିବାରେ ମୁଁ ଦେଖି ନାହିଁ। ତା 6/2/2022 ସନ୍ଧ୍ୟା ପ୍ରାୟ 7:30 ମ୍ୟାଡାମକୁ ଫୋନ କରି ପଚାରିଲି ଆଶ୍ରମ କିଛି ଖାଇବା ଜିନିଷ ଆସିଛି। ସେ କହିଲେ ମୁଁ 2 ଘଣ୍ଟାରେ ପହଞ୍ଚୁଛି। ମୁଁ ଫୋନ ରଖିଦେଲି। ତାପରେ ଖାଇବା ସମୟ ହେବାରୁ ମ୍ୟାଡାମକୁ ପୁଣି ପ୍ରାୟ 9ଟାରେ ଫୋନ କରି ପଚାରିଲି। ମ୍ୟାଡାମ କହିଲେ ମୁଁ ଯିବିନି, ଯାହା ଖାଇବା କଥା ଖାଇଦିଅ, ଯାହା ବଳିଛି ଫ୍ରିଜରେ ରଖିଦିଅ। ମୁଁ କହିଲି ନହେଲେ ଝୁନା ଦିଦିକୁ ପଠେଇ ଦିଅ। ସେତିକି ବେଳେ ଝୁନା ଦିଦି ହସିଦେଲେ। ସେଠୁ ମୁଁ ଜାଣିଲି ଝୁନା ଦିଦି ମ୍ୟାଡାମଙ୍କ ପାଖରେ ଅଛି। ତାପରେ କହିଲେ ଝୁନା ଦିଦିର ପୁଅକୁ ପଠେଇ ଦିଅ, ସେ ଆସି ଖାଦ୍ୟ ନେଇଯିବ। ସେଇଠୁ ତାଙ୍କ ପୁଅ ଆସି ଖାଇବା ନେଇଗଲେ। ପୁଣି ଥରେ ମ୍ୟାଡାମ ରାତିରେ ମତେ ଫୋନ କରି ପଚାରିଲେ ତୁ ମାନସ ରୁମରେ ଶୋଇଛୁ କି? ମୁଁ କହିଲି ନା ମୁଁ ଗେଷ୍ଟ ରୁମରେ ଶୋଇଛି। ତାପରେ ମତେ ରାତିରେ ମ୍ୟାଡାମ କି ଝୁନା ଦିଦି ଆଉ ଫୋନ କରିନାହାନ୍ତି। ତା ପରଦିନ ତା 7/2/2022 ସକାଳ 8ଟାରେ ମ୍ୟାଡାମକୁ ଘରକୁ ଗଲି। ଭାଉଜଙ୍କୁ ପଚାରିଲି ମ୍ୟାଡାମ ଆସିନାହାନ୍ତି କି? ସେ କହିଲେ ମ୍ୟାଡାମ ନାହାନ୍ତି। କିଛି ସମୟ ବସି ଭାଉଜ ସହିତ କଥା ହେଇଥିଲୁ। ଝୁନା ଦିଦି ଭାଉଜଙ୍କ ଫୋନକୁ ଫୋନ କଲେ। ଭାଉଜ ପଚାରିଲେ ଆଣିଲେ ତାକୁ? ଝୁନା କହିଲା ରାତି ଅନିଦ୍ରା ହେଇକି ତାକୁ ଧରିକି ଆଣିଲୁ। ତାପରେ ଭାଉଜ କହିଲେ ଟିକେ ଭିଡିଓ କଲ କଲେ ମୁଁ ଦେଖିବୁ। ସଙ୍ଗେ ସଙ୍ଗେ ଝୁନା ଦିଦି ଭିଡିଓ କଲ କରି ମାନସକୁ ଦେଖେଇଲେ। ମୁଁ ମଧ୍ୟ ଭିଡିଓ କଲରେ ଦେଖିଲି ମାନସ, ରାଜ ଭାଇ ଆଉ 2ଟା ପିଲା କାରରେ ବସିଛନ୍ତି। ତାପରେ ଭିଡିଓ କଲ କଲା ପରେ ଭାଉଜ ଫୋନ ରଖିଦେଲେ। ମତେ ଭାଉଜ କହିଲେ ଆଶ୍ରମକୁ ପଳା, ମ୍ୟାଡାମ ଆସିବେ। ତେଣୁ ମୁଁ ଆଶ୍ରମକୁ ଆସିଗଲି। ମୁଁ ଆଶ୍ରମକୁ ଆସିବା ପରେ ଦିନ ପାଇଁ 11:30ରେ କଲିଂ ବେଲ ମାରିବାରୁ କବାଟ ଫିଟେଇ ଦେଲି ଓ ଦେଖିଲି ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ, ଝୁନା ଦିଦି, ରାଜ ଭାଇ, ମାନସ ଭାଇ ଆଉ 2ଟା ପିଲା। ସେମାନଙ୍କୁ ଆଗରୁ କେବେ ଦେଖିନି କିନ୍ତୁ ଦେଖିଲେ ଚିହ୍ନି ପାରିବି। ସମସ୍ତେ ମିଶି ଆଶ୍ରମକୁ ଆସିଲେ ଓ ମାନସକୁ ଉପର ରୁମକୁ ନେଇକି ଗଲେ। ତାପରେ ଅଳ୍ପ ସମୟ ପରେ ମୁଁ ବାହାର ଗେଟ୍ ଦେଇ ଉପରକୁ ଗଲି ଓ ରୁମ ବାହାରେ ଥାଇ ଦେଖିଲି ମାନସ ଭାଇକୁ ରାଜ ଭାଇ ଆଉ 2 ଜଣ ପିଲା ହାତରେ ମାରୁଥିଲେ ଓ ସାର୍ଟ ଖୋଲି କହି ସାର୍ଟକୁ ଭିଡିଥିଲେ। ମ୍ୟାଡାମ ଓ ଝୁନା ଦିଦି ପାଖରେ ଠିଆ ହେଇଥିଲେ। ଅଳ୍ପ ସମୟ ପରେ ମ୍ୟାଡାମ ମତେ ଛୋଟ ତାଲା ମାଗିଲେ ବାଲକୋନି କବାଟ ଦେବା ପାଇଁ। ମୁଁ କହିଲି ତାଲା ନେଇ। ସେଠୁ ମାନସକୁ ମ୍ୟାଡାମ, ଝୁନା ଦିଦି, ରାଜ ଭାଇ ଓ ତାଙ୍କ ସାଙ୍ଗମାନେ ମିଶି ମୁଁ ରହୁଥିବା ରୁମକୁ ଆଣିଲେ। ସେଠି ଖାଇବା ଜିନିଷ ଥିଲା। ମୁଁ ଖାଲି କଲି ଓ ରାଜ ଭାଇ ଖଟ ବାହାର କଲେ। ମୁଁ ଯେତେବେଳେ ବାସି ଖାଇବା ଜିନିଷ ବାହାରେ ପକେଇ ଆସିଲି ଦେଖିଲି ରାଜ ଭାଇ ମାନସ ଭାଇର ମୋବାଇଲ ଓ ATM କାର୍ଡ ନେଇଗଲେ ଓ ରାଜ ଭାଇ କହିଲେ ହେଲୋ କହିଲେ ତାର ମୋବାଇଲ ଲକ୍ ଫିଟିବ। ମାନସ କହିଲେ ହେଲୋ କହ। ସେ ହେଲୋ କହିଲା। ହେଲୋ କହିବାରୁ ଲକ୍ ଫିଟିଗଲା ଆଉ ATM କାର୍ଡର ଚାବି 4ଟା ନମ୍ବର ମାଗିଲେ। ମାନସ ଭାଇ ଦେଇଦେଲା। ତାପରେ ମାନସ ଭାଇକି ରଖିଥିବା ରୁମରେ ମ୍ୟାଡାମ ବାହାର ପଟୁ ଗେଡା ଦେଇ ଚାବି ପକାଇ ଦେଲେ। ଚାବି ତାଙ୍କ ପାଖରେ ରଖିଥିଲେ। ତାପରେ ସମସ୍ତେ ପଳେଇଗଲେ। ମତେ କହିଲେ ଆଶ୍ରମରେ ଚାବି ଖୋଲିବୁନି କି ମାନସ ସହିତ କଥା ହେବୁନି। ସମସ୍ତେ ଗଲା ପରେ ମୁଁ ମୋର ମା କୁ ଫୋନ କରିଥିଲି ଓ କହିଲି ଆମ ଗାଁର ଗୋଟେ ପିଲାକୁ ଆଣି ଆଶ୍ରମରେ ମାରପିଟ କରୁଛନ୍ତି। ମା ପଚାରିଲା କଣ ପାଇଁ? ମୁଁ କହିଲି ମୁଁ ଜାଣିନି। ମା କହିଲା ସେ ଯାହା କରୁଛନ୍ତି କରନ୍ତୁ, ତୁ ସେଥିରେ ମୁଣ୍ଡ ପୁରାନି। ପୁଣି ରାତି ସମୟ ପ୍ରାୟ 7:30 ହବ। ମ୍ୟାଡାମ, ଝୁନା ଦିଦି, ରାଜ ଭାଇ ଓ ତାଙ୍କର ସାଙ୍ଗମାନେ ମିଶି ଆଶ୍ରମକୁ ଆସିଲେ ତଳ ଅଫିସ ରୁମକୁ। ସେମାନେ କଣ କଥା ହେଲେ ମୁଁ କହିପାରି ନାହିଁ। ସେଠୁ 2 ଜଣ ଆସି ଉପର ରୁମକୁ ଗଲେ। କିଛି ସମୟ ସେମାନଙ୍କ ମଧ୍ୟରୁ ଜଣେ ତଳକୁ ଆସି ମତେ ନ ଡାକି ସିଧା ଗେଟ୍ ଖୋଲି ବାହାରକୁ ଗଲା। ତାପରେ ମୁଁ ଭିତର ପଟୁ ଗେଡାଇ ଦେଇଦେଲି। ଅଳ୍ପ ସମୟରେ ପୁଣି କଲିଂ ବେଲ ମାରିବାରୁ ମୁଁ ଗେଟ୍ ଖୋଲିଲି। ଭିତରୁ ବାହାରକୁ ଯାଇଥିବା ପିଲାଟି ହାତରୁ ଗୋଟିଏ ବାଉଁଶ ଡେଙ୍ଗା ଧରିକି ଆସିଲା ଓ ମତେ ରାଗିକି କହିଲା କବାଟ କେତେ ଦେଇଛୁ? ମୁଁ ଆଉ କିଛି କହିନାହିଁ। ମୁଁ ଟିଭି ରୁମକୁ ପଳେଇଗଲି ଓ ତାପରେ ସେ ପିଲା ପଛେ ପଛେ ମ୍ୟାଡାମ, ରାଜ ଭାଇ, ଝୁନା ଦିଦି ଉପରକୁ ଗଲେ। ମୁଁ ଟିଭି ରୁମରେ ସାଉଣ୍ଡ କମ କରି ଅନ୍ୟମାନଙ୍କ ସହିତ ଟିଭି ଦେଖିଲି। ସେତେବେଳେ ଉପର ମହଲରୁ ବାଡିଆ ପିଟା ଶବ୍ଦ ଶୁଣିବା ସହିତ ମାନସକୁ ଗାଳି ଗୁଲଜ ଓ ଧମକ ଦେଇ କଣ ସବୁ ପଚାରୁଥିବାର ମୁଁ ଶୁଣିଥିଲି। ସେ ମ୍ୟାଡାମ, ରାଜ ଭାଇ, ଝୁନା ଦିଦି ଉପରେ ଯାଇ ବାଡିଆ ପିଟା କରୁଥିଲେ। କିଛି ସମୟ ପରେ ଝୁନା ଦିଦି ଆସି ମତେ କହିଲେ ଟିଭି ସାଉଣ୍ଡ କଣ ପାଇଁ କମେଇ ଦେଖିଛୁ? ଟିଭି ସାଉଣ୍ଡ ବଢେଇକି ଦେଖ। ସେମିତି କହିବାରେ ଆମେ ଟିଭି ସାଉଣ୍ଡ ବଢେଇକି ଦେଖିଲୁ। କିଛି ସମୟ ପରେ ଜଣେ ମଉସା ଡରିକି ଧଇଁସ ହେଇ ଉପର ରୁମକୁ ତଳକୁ ଆସି टीवी रूम रे बसिले ओ आमे समस्ते मिसी टीवी देखिलु प्राय 1.5 घंटा ପରେ ମତେ ମ୍ୟାଡାମ ଉପର ମାନସକୁ ରଖିଥିବା ରୁମ କୁ ଡାକିଲେ ଓ କହିଲେ ଏସବୁ ଓଳାଓଳି କରିଦେ ଗାମୁଛା ଅସନା ହେଇଛି ଏଇଟା ନେଇକି ଡଷ୍ଟବିନ ରେ ପକାଇ ଦେ ମୁଁ ଦେଖିଲି ସେଟାରେ ବାଉଁଶର ଗୁଣ୍ଡ ଖଣ୍ଡ ଖଣ୍ଡ ସବୁ ତଳେ ପଡୁଛି ତା ଉଠାଇଲି ଅସନା ଗାମୁଛା ନେଇ ଘରେ ଥିବା ଡଷ୍ଟବିନ ପକେଇଲି ମାନସକୁ ରଖିଥିବା ରୁମ କୁ ଓଳାଓଳି କଲା ବେଳେ ମୁଁ ଦେଖିଲି ମାନସ ତା ହାତରେ ଆଙ୍ଗୁଠି ଫାଟିଥିଲା ଓ ରକ୍ତ ବାହାରୁଥିଲା ଓ ତା ଦେହରେ ସାର୍ଟ ନଥିଲା ମାନସ ଖୋଲା ଦେହରେ ଥିଲା ମୁଁ ବାଉଁଶ ଖଣ୍ଡ ଗୁଣ୍ଡ ଅସନା ଗାମୁଛା ରଖିଥିବା ଡଷ୍ଟବିନ ଧରି ତଳକୁ ଆସିଲି ଓ ସେମାନେ ସମସ୍ତେ ମାନସ ରୁମ ରେ ଥିଲେ ତାର କିଛି ସମୟ ପରେ ମ୍ୟାଡାମ ଝୁନା ଦିଦି ରାଜ ଭାଇ ଓ ତାଙ୍କର 2 ଜଣ ସାଙ୍ଗମାନଙ୍କୁ ଆଶ୍ରମକୁ ବାହାରୁ କାରରେ ନେଇକି ଗଲେ ମୁଁ ଡଷ୍ଟବିନ ରେ ଅଳିଆ ସବୁ ଆଶ୍ରମକୁ ବାହାରେ ଥିବା ଡଷ୍ଟବିନ ରେ ପକା ପାଇଁ ଗଲି କିଛି ସମୟ ପରେ ମ୍ୟାଡାମ ଝୁନା ଦିଦି ରାଜ ଭାଇ ଓ ତାଙ୍କର 2 ଜଣ ସାଙ୍ଗମାନଙ୍କୁ ଆଣି ଆଶ୍ରମକୁ ଫେରିଲେ ଆସିବାରେ କିଛି ସମୟ ପରେ ମ୍ୟାଡାମ ମତେ ଉପରକୁ ଡାକିଲେ କହିଲେ ଖାଇବା ଟାଇମ ହେଇଗଲାଣି ମଉସାକୁ ଭୋକ ହେଲାଣି ଖାଇବାକୁ ଦେଇଦେ ମାନସ ପାଇଁ ଖାଇବା ଦେ ମୁଁ ଦେଇଦେବି ମ୍ୟାଡାମ କହିବା ଅନୁଯାୟୀ ମୁଁ ତାକୁ 4 ପଟ ରୁଟି ଓ ସୋୟାବିନ ତରକାରୀ ଦେଇଦେଲି ମ୍ୟାଡାମ ଖାଇବା ନେଇ ମାନସକୁ ରଖିଥିବା ରୁମ ଭିତରୁ ଗଲେ କହିଲେ ଯଦି ତୁ ତଳେ ଝାଡା କରିବୁ ସକାଳେ ଆସିଲେ ତୁ ମାଡ଼ ଖାଇବୁ ମୁଁ ତାପରେ ତଳକୁ ଚାଲିକି ଆସିଲି କିଛି ସମୟ ପରେ ମ୍ୟାଡାମ ସେଇ ରୁମକୁ ବାହାର ପଟୁ ଗେଡା ଦେଇ ଚାବି ପକେଇଦେଲେ ଝୁନା ଦିଦି ରାଜ ଭାଇ ଓ ଅନ୍ୟ 2 ଜଣଙ୍କ ସହ ଉପର ରୁମକୁ ତଳକୁ ହାଲିଆ ଝାଳନାଳ ହୋଇ ତଳକୁ ଆସିଲେ ଓ ଆଶ୍ରମକୁ ପଳେଇଗଲେ ସେମାନେ ସମସ୍ତେ ଗଲା ପରେ ମୁଁ ଆଶ୍ରମରେ ଗେଟରେ ଚାବି ପକେଇଦେଲି ଓ ଶୋଇପାଇଗଲି ମ୍ୟାଡାମ ମତେ ମାନସ ସହିତ କଥା ହେବାକୁ ମନା କରିଥିଲେ ତେଣୁ ମୁଁ ଡରିକି ଅନ୍ୟ ରୁମରେ ଯାଇ ଶୋଇଲି ତା ପରଦିନ 8/2/2022 ମୁଁ ମ୍ୟାଡାମକୁ ସକାଳୁ ଦେଖିନି କାରଣ ମୁଁ ଅନ୍ୟ କାମରେ ବ୍ୟସ୍ତ ଥିବାରେ ଗେଟର ଅନ୍ୟମାନେ ବି ଗେଟ ଖୋଲନ୍ତି ଦିପହର ଖାଇବା ଟାଇମରେ ମ୍ୟାଡାମଙ୍କ ସହ ରାଜ ଭାଇ ଝୁନା ଦିଦି ଓ ସେଇ 2ଟା ପିଲା ମଧ୍ୟ ଆଶ୍ରମକୁ ଆସିଲେ ମତେ ଗେଟ ପାଖରେ ଶର୍ମିଷ୍ଠା ମ୍ୟାଡାମ 100 ଟଙ୍କା ଦେଲେ ଓ କହିଲେ ମୋର ଶାଢୀ ଯାଇକି ସୁନଲତା ଟେଲର ପାଖରୁ ଆଣିଦେବୁ ମୁଁ ନମ୍ବର ମାଗିଲେ ମ୍ୟାଡାମ କହିଲେ ମେସେଜ କରିଦେବି
So, in between the murder has taken place
Yes.
and the dead body has been disposed of.
ସବୁ ଜାଗାରେ ଯୋଉ କହୁଛନ୍ତି ଅନ୍ୟ 2 ଜଣ ପିଲା that
Was any TI period held?
TI period held. Yes.
not identified.
Yes, yes. One
This Nilu alias Bibek.
yes, Sarat Chandra Panda, PW1, your lordship.
That is not in that case, Your Lordship. That is so far a trial phase by the
JGR,
not accused person.
JGR. JGR.
That is not with you.
PW1 Sarat Chandra Panda. From the kidnapping, he was there. He was identified.
Amongst the 4 persons identified by me, the CICL Vivek Naik was identified by me.
Yes.
2 I identified today also in court through computer screen video conference.
Para 6.
Para 6 is clearly there.
Yes.
Yes. Identify each.
Sir, was identified me to whom I identified today also in the court through computer screen video conference, Lordship. Prior to this, Your Lordship, there was a video conference. The person is several times attended the court, Your Lordship.
No.
Now, what is the credibility so far that TI identification part is concerned?
Amongst the 4 persons identified by me, the CICL Vivek Naik was identified by me, to whom I identified today also in the court through computer screen video conference. মানে আগুরু মু TI period করতেলে আজি computer screen রে দেখছি। So it is not a question of first time identification in court.
Then has to, Your Lordship, when the TI period has been, Your Lordship, conducted and so far the arrest part is concerned, in between there must be some time gap, Your Lordship. In the when there is a UTP, Your Lordship, every 15 days they are attending the court. Every 15 days. And definitely in the meanwhile there has been.
তাহলে এই TI period জিনিসটা তো পুরা গলা। তাহলে TI period জিনিসটা পুরা গলা হবনি।
No, this is one thing, Your Lordship.
হবনি তো?
However, Lordship, a glance I am a CICL, Your Lordship. And so far the socio-investigation report that is not against me. And my father has also been filed an affidavit. And so far the Niranjan Satta part is concerned and the person who has been given leading to discovery and another person who has also made arrangement, they have been released on bail, their certificate copy.
Who are these 4 suspects who were identified? Yes, Mr. Mishra. Please find out, I'm coming within 5 minutes.
Yeah. Yes.
What, any specific overt act has been attributed?
My lord, I am reading from the charge sheet. The statement of accused Raj alias Ranjan Naik was received under 27 Evidence Act, and the articles which are used for the disposal of dead body were recovered at his instance. And statement of accused Sarmista Raut was recorded under 27, and the places from which the deceased was abducted, the place where he was confined and assaulted, and the place where the dead body was buried was duly identified by her with details of offensive transaction. Further, in the course of investigation, as the witnesses at the place of kidnapping and the place of confinement identified the accused persons for the first time with due procedure, TI parade of accused persons were held on 21/4/22.
No, Mr. Mishra, you don't get the point. My point is, there are three spots. One is from where he was kidnapped. Second, he was brought to the ashram, where he was assaulted, which led to his death.
Yes.
They were assaulting him probably because of something he died. देखिले से मर गया तो पता है dead body dispose of. So this is the third spot.
Yes.
There is, as he was reading out, ଦି ଜଣ ପିଲା ଆସିଥିଲେ ତା ସାଙ୍ଗେ,
ଦି ଜଣ ପିଲା
ସେ କଥା ସେ ବାରମ୍ବାର କହୁଛନ୍ତି।
ବାରମ୍ବାର, yes।
ସେ ଯୋଉ ଦି ଜଣ ପିଲା ଆସିଥିଲେ ସେମାନେ ତାଙ୍କ ଏଗେନ୍ଷ୍ଟ ସ୍ପେସିଫିକ ଓଭର ଆକ୍ଟ କଣ ଅଛି?
କିଛି ନାହିଁ। All through the records nothing. Specific overଟା ସର assault ପାଇଛି ରାଜ ନାଁରେ ଆଜ୍ଞା ଅଛି, ଏମାନ ନାଁରେ କିଛି ନାହିଁ।
ତାପରେ ଲେଖିଲେ, I am reading my lord, that as per the TI parade report, the accused persons, namely Bhagi alias Bhagidhar Naik and Nilu alias Vivek Naik, were correctly identified. The witness Soni alias Sarojini Sittha.
No, let us accept it.
Yes,
let us accept that he has been identified. I am not accepting his objection to the. I have said it. I am not accepting his objection. Let us accept. But ସେମାନେ କଣ ଥିଲେ? What was their role? What was this man's role? That is what I would like to know.
He was present during the assault, my lord.
If he was present, 34 will be entangled, that is all right.
Yes.
But what was the any specific overt act? Because somebody else has been granted bail, as he was rightly.
Yes, no, they were on not similar footing, my lord.
They
are
the part of the gang. So far, Niranjan Sethi is
only sent the money to the principal accused, that Parmeswar Raut. And that Niranjan,
I filed, and Niranjan Raut
Astula Jautula. He was not present that day during the assault.
Niranjan Sethi was a part of the gang while he was confined in the house. It is the statement of while confined in the house and given assault by the
Parmeswar Raut is totally different.
Totally different. But so far Niranjan Sethi and other persons concerned, other person given leading to discovery, and Niranjan Sethi is actively participated in lordship. He was present although there is no allegation against him, but he is unlawful assembly part of that. On the day he was taken to the assault room, by that time Niranjan Sethi was there in view of the statement of Sarmista Sethi, your lordship.
Who is the principal accused?
Sarmista.
The lady.
Sarmista.
The lady.
Sarmista.
So there was a spectrographic test also was conducted.
Yes.
Parmeswar Raut has been which might have been murdered by someone else and his dead body being disposed of over a path. You read the 27th statement. I'd like to know what is the role played by this person.
Super Raj Naik is considered.
Anybody?
Raj.
Any other? There are two persons, no?
I'm replacing the statement of 27 for Raj is concerned.
See person टा खाली पढ़ो जोठरे से याको कथा कोइछ कोन केमिति मारले कोन कले
6/2/22 रे हमर पूर्व आलोचना से शर्मिष्ठा मैडम के गुरुत्वपूर्ण मेमोरी चिप कैमरा मानस सेंटर चांदबेल आनिबा निमित्त तांको से मु भाग्यधर विवेक और झुनामय मैडम को कार चांदबेली पळसपुर गलु सेठारे मैडम मानस स्वाई को सही मेमोरी चिप मागिलो से न देबर ताको दुई चापड़ा मारले मैडम मारले मानस स्वाई की सही गाड़ी जोर जबरदस्त बसाई आमे शर्मिष्ठा मैडम को भुवनेश्वर दयाल आश्रम रे 7/2/22 दिन 11:30 रे पहुंचलु से मानस को नहीं से आश्रम पर मोहलार गोटे रूम रे रखिलु और बाहर पटू मैडम खिड़की दे देले मैडम झुना भई भाग्यधर विवेक सेटर थिबा बाउंस फाळिया मारिले मैडम शेष रे
मारले
मैडम झुना भई रिलीजन इंटरिम बेल भाग्यधर विवेक सेठारे थिबा बाउंस फाळिया मारिले मैडम शेष रे मानस को पुणी सही आश्रम पर रूम भीतर पुराई देले और बाहर पटे ताला पकाई देले ରାତି ପ୍ରାୟ 9:30 କି 10 ସମୟରେ ମୁଁ ଜାଗବରା ଆସିଲି ଓ ଭାଗ୍ୟଧର ଓ ବିବେକ ସେମାନେ ଘରକୁ ଗଲେ। ତା 8-2 ଦିନ
ଶୁଣନ୍ତୁ ଏଗୁଡା ତ inadmissible. ଆମେ ଖାଲି ଜାଣିବା ପାଇଁ ଚାହୁଁଥିଲୁ.
ଆଜ୍ଞା।
These are all inadmissible statements. But then this is the what actor I wanted to know. ସେଇ 4 ଜଣ ଯୋଉମାନେ ମାରିଛନ୍ତି ଉପରେ ଇଏ ବାବୁ ଜଣ ଥିଲେ ତା ଭିତରେ
Confession
Niranjan Reddy was
statement
not
ସେ
there.
କହୁଛନ୍ତି।
At Parmeswar Rao, those who were granted bail, they were not.
ସେମାନଙ୍କର
Confession
totally
statement.
different.
Yes.
And another thing, your lordship, so far the PW1 cross-examination, your lordship, a glance what
Yes.
is step to the cross-examination.
Yes.
I do not know the names, parents, and the address of the CICL facing trial in this case and other.
ଦରକାର ନାହିଁ ସେ ଆଇଡେଣ୍ଟିଫାଇ କଲା ବାଇ ଫେସ୍ ଆଉ ନାଁ ଗାଁ ଜାଣିବା କଣ ଦରକାର?
ଯାଉଛି ତା ତଳକୁ ଯାଉଛି ସେଟା ଯାଉଛି ତଳକୁ ଯାଉଛି। I was at Itua when Bhagirathi Siri called me, but I cannot say from which telephone number Bhagirathi had called me, and I cannot say how many telephone calls I had received on that day. On 6/2/2022, there was a wedding in Palsara village, and I do not remember the name of the person who we are getting married during that time. I meet Sharmishta on 6/2/2022 at about 11 p.m. near Itua Chako. And near the spot, there was a shop whose owner's name I do not know when, which was closed as it was late night. I have found Sharmishta arriving in a Santrokar, and I had met Sharmishta for a period of 5 minutes in the night time, which was dark. As it was a dark night, I could not properly see the dress of Sharmishta and others who were in the LA Santrokar and who arrived in Ituachoko. The person who came from the Santrokar to Ituachoko in the night 6/2/2022, we are of different heights and appearance, but I cannot say about the peculiarity of their appearance, lordship.
Come to paragraph 19. Nineteen and 20 relate to you. Hold on.
Chief, your lordship.
Para 19 টা পড়ুন।
This is the chief, your lordship.
ये chief টা?
Chief tiger.
नहीं नहीं সেটা cross examination চলছে। para 19 পড়ুন।
Further cross examination.
Yes, further question. When I went to the jail, one of the person who told me to identify the suspects in connection with another case originating from the same affair in the court of justice of Bhadrak. I have already given my evidence during which I have not spoken against the CSL or his identity. And now I am giving evidence against the CSL BP, but I do not remember his surname in the case. I do not remember what exactly I have settled before the police and the magistrate in the connection with this case. Then 20, it is not a fact that I am deposing falsely, being connivance with the police of to falsify implicate the SASL without prior identification.
This is what takes away. This nullifies. He admits that ମୁଁ ସେ କେସରେ କିଛି କହିନଥିଲି CICL against it. Statement of a witness has to be consistent. To test the veracity, the normal human conduct is that he will say the same thing which he has seen. କଥାକୁ ଲଥା ଟିକେ ହେଇପାରେ କିନ୍ତୁ ଏଠି ସେ କଣ କରେ? I have not spoken against the CICL or his identity, and now I am giving evidence against CICL. This is being said. This assumes significance in the absence of any further corroborative and admissible evidence. What else you have is all inadmissible. 27 ରେ ସେ ଯାହା କହିଛନ୍ତି ସେଗୁଡା ତ ନିଆଯିବନି. So this is a point. All right.
And she has also that eyewitness has also identified her in that year.
Kahin identify?
She has not been examined, my lord. But that Sarojini Sitta. He also says.
नहीं सीधे पढ़िले पूरा statement ना.
One statement पूरा पढ़े.
And that also seems to be at variance from her earlier statement before the police.
Yes, my lord.
And before CBI, or the crime branch probe.
Yes.
Crime branch. She gives a different version. She doesn't name her. Name this guy.
Before the police, but she has named.
All right. Where's the social investigation report?
Yes.
What does it say? ये लोगों का बयस केते? ये पिलारो? 19 years.
17 years, 10 months, 22 days on the date of commission of crime.
Now it is 19. But I have no criminal privilege.
Any other person similar to this person who has been granted bail?
No.
Only if your lordship,
Here group
if your lordship say can do the unlawful assembly, then Niranjan Sethi lordship.
Juna Bohi I have rejected.
Juna has given your lordship interim bail lordship.
No, I have also rejected earlier, thereafter I have given
Yes,
interim bail. Juna Bohi, very strong materials are there against us.
Yes,
Against Juna Bohi and that other lady,
Sarmishta Rao.
Sarmishta Raut. That also I think I have rejected.
Yes.
Swarmishta rejected your lordship, and so far Juna Bui getting
Tolerant.
interim bail.
Juna Boy, some
The appellant.
element.
The appellant is a CICL and is in custody
28/3/2022
since 28/3/2022 in connection with such and such case. The prosecution allegation is that one Manas Ranjan Swai was kidnapped at the instance of one Sarmistha Raut and taken to an ashram where he was severely assaulted and ultimately killed. It is alleged that some other persons, including the appellant, were present at the spot and had jointly assaulted the deceased. Subsequently, all of them carried the dead body to a faraway place and buried it to conceal the evidence. Stop. Several persons were arrested in course of investigation, including the principal accused, Sarmishta Sethi, whose bail application has been rejected.
Sarmishta Rao.
Sarmishta Raut, whose bail application has been rejected. The bail application of another co-accused, namely Juna Sethi, Juna Bhoi, has also been rejected. Though subsequently she was granted interim bail. Insofar as the present appellant is concerned, Sri Prabhas Kumar Jena, Learned Counsel for the Prabhas Chandra Jena. Prabhas Chandra Jena, Learned Counsel for the appellant, would argue that there is no admissible evidence to show the complicity of the appellant, save and except the TI period, the TI period. Stop. Though PW1, Saurabh Chandra Panda has deposed about the TI period, yet in cross-examination, he clearly admits that he had not stated anything against the appellant or his identity in the original case tried by the Sessions Judge Bhadrak. So, Sri Jena further submits that the witness whose statement is strongly relied upon by the prosecution, namely Sarojini Sitha, has given prevaricating statements in as much as at the initial stage she had named the CICL.
Yes, sir.
She had named the CICL. But in her subsequent statement recorded by the crime branch, she did not whisper his name. Sri S.K. Mishra, Learned Parath, State Counsel, opposes the prayer for bail by submitting that there is the evidence of PW1 who identified the CICL during the TI period, as also in court, cannot be questioned. Stop. The grounds raised by the counsel for the petition appellant are relatable to minor contradictions which cannot be treated as fatal to the prosecution case. Para. After considering the rival submissions and on going through the materials available in the case diary, including the statement of Sarojini Sitha, this court finds that save and accept some evidence to show that the appellant was present at the spot at the time of the occurrence. There is no clear-cut and admissible evidence to show admissible evidence attributing any specific overt act to him. Stop. Though prosecution relies upon the disclosure statement of co-accused
Raj
Raj alias Ranjan
Naik, but the same is obviously inadmissible to the extent inadmissible save and except the part relating to discovery of the weapon of offense. Yeah, to? Weapon of offense, bamboo stick.
assault. Yes, bamboo stick.
Bamboo stick. If all these materials are left out, comma, there is no admissible evidence worth the name to show the complicity of the petition appellant. Stop. Moreover, the apparent contradiction in the statement of PW1 further weakens the case of the petitioner as against the appellant. Taking into consideration all the above facts, as also the social investigation report submitted by the CIC, PI, which officer?
Child Welfare Police Officer.
A CWPO. I find no reason to direct detention of the petitioner, detention of the appellant, having regard to the fact that, particularly when he has already spent
2 years, 7 months.
2 years and 7 months in the observation home. Further, his father has also sworn an affidavit to the effect that he shall affidavit. His father, Bimal Naik, alias Nahako, has also submitted an affidavit specifically stating that he shall abide by any condition to be imposed by this court while granting him bail, and has also undertaken to provide food, shelter, clothing, better education, better surrounding, and better health to the CICI. So, taking into consideration all the above factors, I am inclined to take a lenient view. Let the appellant be released on such terms and conditions as the Juvenile Justice Board.
Yes, ma'am.
JJB court है जगह.
JJR case number 12 by
ना ना कोई जगह रो board.
अरे ADJ को children's court रहेगा.
अच्छा. As the court below, court in session over the matter may deem fit and proper to impose, including the following conditions. 1. Surety beta कर दो तो कोटे तक वापस आ गया. Out of 2 sureties for such amount as may be specified by the court below, one of them shall be the father of the appellant. Stop. Next, he shall appear before the court below on each date of posting of the case without seeking representation. Next. He shall also appear before the see, child officer key.
My lord,
That's it's not a police officer, other.
yes, my lord. DSP, CID.
No, not the police officer.
Child Welfare Police Officer. That
No.
she has
Setik
given
na.
signature, Kalpana Sahu, OPS,
All right, Setik.
Deputy SP.
Yes,
CIDC.
Yes.
Item 45.
Continue.
May it please your lordship.
Yes, sir.
The petitioner has been in custody since 19/9/22.
Santosh Das.
Madam. He-
After examination of material witness, including injured Sagar Das,
Okay, Sagar Das
has been examined.
PW8.
I have given that PW8.
Right.
I have given the evidence of all.
PW8.
My lord.
Yes.
What has he said?
Para 2
He
and
has, it
in the
is,
cross examination,
he stated that he was the pillion rider and the deceased was assaulted and he himself was assaulted.
You are Santosh Das.
I am Santosh Das.
And
He
also the-
himself was assaulted. But there, and he sustained injuries, that is why 307 is there. But he said that I was,
कौन लिखला? On that day, I accompanied with the deceased Kalyana. Kalu had been to Marathi Sai to bring pork meat. Hey,
Okay.
oh. After bringing meat while we were returning, the accused persons, namely Santosh Das, Dakkar Das, Kuna Das, along with one Langar and other lazy attacks against his home. That's it. Ranka Das was holding one Kati, Kuna Das was holding one sword.
cross examination, para 6.
Cross examination आने कौन आवश्यकता? कुछ बुझी पाने की?
there are two, your lordship may go to.
No, I mean,
Yes, your lordship knows the way now cross examination is being conducted. Very pathetic condition.
Omnibus thila ethi specify
ये specify करो
ଆଜ୍ଞା,
ना.
ଆଜ୍ଞା।
हमें डिफेंस स्पेसिफाई करो ये खंडा करतला ये काती करतला ये करतला.
ନାଇଁ ସେମାନେ ଆଜିକାଲି ଆଜ୍ଞା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ମାନେ ସେମାନେ ଜାଣିନାହାନ୍ତି ହ୍ୱାଟ ଇଜ କ୍ରସ୍ ଏକ୍ସାମିନେସନ
Very clear. ଏଥର କହିବା କଣ ଅଛି?
କିନ୍ତୁ ସେ ମେଡିକାଲ ଏକ୍ସାମିନ ହେଇନାହିଁ
I have been a session judge, sir. I know.
ଖାଲି
Pathetic.
ଦୁଃଖ ଲାଗିବ କିଛି କରିପାରିବେ
Yes.
16.
Sometimes what we do in these cases where there is material, the court interferes.
naturally
We start asking questions.
yes yes
Two court କରିକି ଲେଖୁ ନା two court କରି ନ ଲେଖିଲେ ମଧ୍ୟ ଆଉ କଣ କରାଯିବ?
that is what is also the decision that they must take part appropriately
Yes. କଣ କରିବା?
And
so medical examination ହେଇନାହିଁ he has not been medically examined nor is it the case that he was medically examined.
Yes.
16 injury has been inflicted on the deceased.
On the deceased.
Yes.
This is କିନ୍ତୁ ଆଉ ଗୋଟେ witness କହୁଛି
Attacked us by means of sword and thanga.
ଆଜ୍ଞା ଇଏ PW
The accused persons also assaulted me by chasing.
my lord
Thereafter, I fled away from them. I was injured and shifted to medical.
my lord
So there is no.
medical report ନାହିଁ କି ଦିଆ ବି ହେଇନି ଚାର୍ଜ ସିଟ୍ ବି ନାହିଁ and he admits that yes
Yes. What other witness you are referring to?
other witness
PW 10, PW 9.
no they have
PW 9.
most of them have resigned. Yes, PW, your lordship will kindly see page 41. That is PW 10,
PW 10 you want me to see?
my lord, page 41.
Go on.
Para 13.
Yes.
Dako dealt blow on the deceased, then the accused Kuno and Dako dealt blow on the deceased.
All right. The petitioner is in custody since
19/9/22.
19/9/2022 in connection with such and such case. The prosecution case is that the petitioner and three other persons jointly assaulted one Montana.
Kalu Nahako.
One Kalucharan Nahak.
ସେଟା 3 नहीं 1 2 3 4 5 6 ଜଣ
The petitioner and five other persons. Jointly assaulted one Kalucharan Nahako.
ଆଜ୍ଞା
Kalucharan.
causing his death. No, by deadly weapons causing his death. It is further alleged that they assaulted the informant Sagar Das, causing injuries on his person. Learned counsel Sri Vasudev Pujari, learned counsel for the petitioner, draws attention of the court to the deposition of
PW8.
Sagar Das PW8, who has been examined as PW8. Sri Pujari would argue that though the said witness specifically stated that he was also assaulted and received injuries and was shifted to medical, yet there is absolutely no evidence, no medical evidence to show, no medical evidence in support thereof. The charge sheet is entirely silent as regards any injury to the said witness. Sri Pujari further refers to the evidence of Minoti Nahak, bracketed PW10, who is an eyewitness and has described the occurrence vividly in cross-examination under paragraph 13. The name of the petitioner is absent. On such basis, it is submitted that there is no evidence to show the complicity of the petitioner in the alleged occurrence. Para. State Council has opposed the prayer for bail by submitting that, regardless of the fact that the injured witness, the injured informant did not sustain an injury, yet fact remains that there is evidence to show that all the accused persons jointly assaulted the deceased, causing his death. Therefore, the complicity of the petitioner cannot be ruled out. Stop. Para. Having considered the rival submissions and on going through the evidence available on record, this court finds that the informant's version is somewhat shaky and cannot be relied upon, particularly when compared to the specific statement of PW10 attributing different acts of assault to different co-accused persons. Stop. Significantly, there is no mention of the petitioner in her evidence. All this creates a reasonable doubt in the mind as regards the involvement of the petitioner in the alleged occurrence. So, in such view of the matter, I am inclined to take a lenient view. Let the petitioner be released each day appearance, without seeking representation. What's just 46, anybody? This is a bail. Earlier order?
Yeah, dear my lord, directed after the examination of material witness.
Yes?
After the examination of material witnesses.
You have come.
In the meantime, 7
Out of 31, 7 examined, and PW4 is the informant, and other material witnesses are yet to be examined.
We will actually
call for the status report. So in the meantime, some period.
The court below is directed to submit a report regarding status of the trial. List this matter. 14th August. 14th August? Yes.
Item 47.
47, my lords. The main prayer and the bail application is interim bail. I'm not pressing for regular.
Sir.
The main prayer is interim bail. He's on account of his mother's illness. Your lordships had asked for a report.
I will ask for a report.
Your lordships had asked for it.
Okay.
3 SCST is also there. Notice has already been served on informant and victim also.
Yes, informant your lordships had also issued.
She is
Her condition is stable.
Yes, my lords. But she needs a heart, this thing, my lords, total checkup. She was in a very downward spiral, my lords.
All right.
Now,
Learned State Council has obtained instructions that the mother of the petitioner was treated on 28/3/2024 and she has no external injury and her health condition is stable. Sri Milan Ganwadi and its senior counsel submits that though the medical condition is described as stable, yet the patient requires further treatment of her cardiological
cardiology, this thing referred to SCB, my lords. Annexure 5.
for which she has been referred to the SCB MCH.
Yes. At page 24.
Notice sufficient age.
Notice sufficient.
Then State Council, then State Council informs that notice on the informant has been served on 8/7/2024. There is, however, no
Informant
appearance.
as well as victim, both.
Informant/victim করবো না? No. There is, however, no appearance from their side. Stop. তারপরে এটা চললা। Considering the above facts, which considering the above materials, which prima facie show that the mother of the petitioner is ill and requires treatment, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 1 month.
Oblige. Let's just, with your lordship's indulgence, there was another matter. Lordships have fixed it up on 28. 28, that is a Sunday, my lords. I'll mention it tomorrow.
Change कर दो।
This is the order.
अरे order भूल ही सब change कर दो।
Aye.
मैं modify कर दूँ ना। ତା ପରଦିନ ଆସିବ automatically. But ଏଇ order ଟାକୁ correct କରିବାକୁ ପଡିବ ନା, ଯୋଉଦିନ ଆସିବ ସେଦିନ ତାକୁ correct କରିବାକୁ
Actually, ଆପଣ mediation ରେ ପଠେଇଥିଲେ। Interim bail ଟା ସରି ଯାଉଛି, ତ mediation ରେ ସେ
So you bring it tomorrow.
Yes.
We can modify it.
Yes.
Bring it tomorrow, we'll modify it.
Aye. Oblige.
Item 48.
Item 48.
Please, your lordship, my lords.
What was the main application, main prayer was for interim
Yes,
bail.
ma'am. Yes.
So dispose of. Yes, Mr. Panda.
I may be excused, my lords. I am there virtually, my lord. 48
Why
here,
are
the
you
petition. Lords, I am there in a remote location today, that's why.
What remote location? Yes, what is this matter?
Here, the petitioner is custody since 26/9/2021 in a case under 302, primarily, my lords. And
Lordship has called for the case diary. Case diary is not available, my lord.
Okay.
Learned has given a number, into sethere case diary nahi, the medical document re mota hai.
Okay.
Case diary nahi.
Okay.
if your lordship remembers, this is that case where the co-accused has been released on interim bail that I
No,
may
we can consider it, but let him obtain the case diary, Mr. Panda.
My lords, I may also have one more small prayer. I have filed an IA. I beg apology, my lords. There is an inadvertent error in the prayer portion of my bail application, for which I have filed an IA for correction. The interim bail has been written. It has to be regular bail. Therefore, I have prayed for a correction in that IA.
IA 8/31/2024. By means of this application, the petitioner wants to amend the prayer portion of his bail application by substituting the word interim, by deleting the word interim, appearing before the word bail. Stop. Since the Learned State Council has no serious objection to this bail application, to this interim application, considering the IA is allowed, the consolidated bail application be filed by within 3 days?
My lords, my lords.
In a week. Further, the State Council shall obtain the case diary, place this
And
matter on.
So also, my lord, as per my instruction, 9 witnesses has been examined. Let them
No,
produce.
my lords, 10 witnesses have been examined. I'll file the copies tomorrow.
All right.
9 witnesses.
Then counsel for the petitioner shall file the copies of the depositions of the witnesses examined so far.
Yes.
Place this matter on
14th August.
14th August.
My lords.
Item 49.
My pleasure.
Present case earlier pending before SDGM Bhubaneswar, now it is transferred to Law and Presiding Officer OPID Court Cuttack. And the case number is also changed. Kindly correction. The petitions are surrendered before the OPID Court Cuttack.
Considering the submissions, order dated 15/2/2024 is modified only to the extent that in paragraph 5, instead of the words court below, the words presiding officer,
OPID Court Cuttack.
OPID Court Cuttack.
In city case number 86 of 2023.
In CP case number?
City case number 86, 2023.
86 of 2023 be inserted. Yeah.
Manner. Okay.
At number 50. Let call them. Correction be made accordingly. As paid for by learned counsel to the respondent, list this matter. You want it next week? Next week.
Subject to payment of.
Really? He was operating the phone inside the court.
With Lordship's permission, item 20 of the weekly list. Yesterday it was called, but we didn't appear, for which it has been passed over. My lord, the noting was that the AD has not returned from the respondent number 2, and tracking report is there. If it has been delivered, then maybe made sufficient. Your lordship.
Item delivered.
Hello?
Notice delivered.
Then your lordship may make, it may be made sufficient and matter may be.
Notice on respondent number 1.
One sufficient.
Is sufficient in view of the, as per the postal tracking report enclosed to the case record.
2, my lord. 2 has not. Respondent number 2.
Sorry, respondent number 2.
Yes.
And who has appeared for the respondent number 1?
That I cannot say. But it has been sufficient.
There is, however, no appearance. Is this matter?
In the week commencing 9th September.
In the week commencing 9th September or interim order to continue?
Oblige.
I mean,
I'm appearing that.
कोई
नहीं say the short, as your lordship has formulated the issue that matters have been within the exclusive jurisdiction of the family court as per the section 7 of the family court vis-a-vis section 9 of the CPC. I have checked up. I mean, it is appropriate, it has wrongly been, your lordship has order 7, rule 10 explanation. In that it may be remitted. So presented with family court.
So let us hear it. Without hearing, how can I? I'll
Would a date court then?
Arabi ko asutale. Next week.
Again.
You have appeared for respondent?
Respondent.
1.
One.
Respondent number 1. 2.
Shri B.S. Das. Shri Jahala Kaisi Jadar Kali Mojero Puri Debe. Shri B.S. Das has entered appearance for respondent number 1. It is stated at the bar that the matter can be disposed of. At this stage. List this matter next week.
Item 47.
Interim order.
Interim order to continue. Yes.
Item 47 of the weekly list.
Yes.
May I pray for being adjourned to the week commencing 12th August.
Item 47. All right. List this matter in the week commencing 12th August.
Pardon to mention, your lordship, item number 44 of weekly list, actually सांग को देह sudden खराबी वाला तो से आज ही घर को बोले ले सर तो काली हे परिवो तो if it can be taken off tomorrow.
All right, pass over for the day. Respondent. Pass over for the day.
Item number 44 and item number 50 as well.
All right.
44.
Item 15 of the supplementary list, my lord. That was in the morning hour, it was passed over. And
No, I will call out the passover matters. I'll call out the passover matters.
Supplementary list, passover item number 15.
Yes. Your matter.
my lord, I am for the opposite party number 4. I was selected.
Who is for the petitioner then?
Mr. Joshi is appearing for the.
सीता appear colony बोली सीट पे मैं passover कर लिया हूँ. None appears for the petitioner. None counsel for the opposite party for number 4 is present. Let's this matter tomorrow. कल यदि appear न करे, we'll dispose of.
Passover item number 16.
Yes, item 16. None appears, disposed of.
Passover item number 42.
Item 42, extension of time, order dated 8/1/24.
42. This has come for the first time.
My lord, first time ଆଗରୁ ଥରେ ଆସିଥିଲା ନା non prosecution ହେଇଥିଲା ନାଟା ଆସି ନଥିଲା.
All right, 2 weeks time.
Okay.
Weekly list item number 41.
Yes.
On behalf of my learned senior members, please, my lords.
Yes. Who's for the other side?
Yes, I think HM Dharo sir.
Is not there, will not there, or 2005 matter, or कौन करे? कौन?
My lords, I have prepared a written note of submission, my lords.
Yes. Pass it on.
My lords. Along with 3 judgment matters, I'll be relying on that later on, my lords.
Yes.
The appellant has come up against a confirming judgment of the lower court, my lords.
Yes.
The appellant was defendant number 1 in the suit, and respondent number 1 was the plaintiff. My lords, the case of the plaintiff is as such. My lords, he claimed that he and all the other defendants, they all are brothers and sisters and children of one B. Madhava Rao.
You have a genealogy?
My lords, I have page number 2, my lords, of my written note.
Let us go to the genealogy straight away.
My lords.
Yes. Madhava Rao is the father.
Yes, my lords.
Yes, then?
Kannakappa is the sister, defendant number 2. Present appellant, my lords, is B. Venkata Rao, T1.
Yes.
Ganapati Rao is the plaintiff, my lords. And Padma is another sister.
So this is a suit for partition claimed by Ganapati Rao. Yes.
Plaintiff has stated, my lords, that there was a relinquishment, registered relinquishment on the part of defendant number 2 and defendant number 3, my lords. That is, both the sisters relinquished their right over the property, my lords. Suit schedule property in item 1 is self-acquired and item 2 is ancestral property. When differences arose between the plaintiff and defendant number 1 about distribution of the said suit schedule property, my lords, there the plaintiff went for filing this present suit, my lords, for partition. Now, my lords, the case of the defendant number 1, the present appellant, is as such. Admitted, my lords, they are all brothers and sisters. Here, what we say is, during the lifetime of B. Madhava Rao, that is father, this person, the plaintiff, he was given an adoption to one Sabitri Amma on the Kotha Amavasya day of the year 1964, after observing a function in the family.
Yes.
Since the date of adoption, the plaintiff has ceased to be a family member of B. Madhava Rao and accepted as the adopted son of Sabitri Amma, thereby curtailing all the rights in respect of properties of.
What is the law in this regard?
My lords, the law says that once somebody is adopted, then all his rights with respect to the property of the biological parents, my lords, that will end, my lords. And the adoptive parents' side property may be inherited. And my lords, our case is also this, that after the death of said Savitri Amma, that adopted mother, my lords, the plaintiff succeeded to her properties, and even Savitri Amma has acknowledged that fact through a gift deed in which she has written that as my Posya Putra, I am giving you this property. My lords, number of witnesses that has been examined are plaintiff witnesses have examined 4 witnesses. First one is the plaintiff himself. Second is the neighbor. Third is one of the sister, that is defendant number 2. Fourth is another neighbor. Defendant's witness, my lords, are 3 numbers. First and second are neighbors, and third is the defendant number 1 himself, the appellant himself. The finding of the court's, my lords, I would like to place before your lordship. First finding was, as per the evidence of witnesses of the defendant, there were a good number of street people and caste men present during the adoption ceremony, but none of the caste men nor competent witnesses of the street were examined to prove the adoption. Though evidence has been led stating performance of function as per caste custom, the caste custom has not been proved through cogent, consistent and convincing evidence. Then, my lords, PW3, that is the sister, my lords, she has also stated that there is no adoption. Then, my lords, a document under Exhibit A, that is the gift deed that was in Telugu. Another Exhibit B is translated version of it in Odia. Gift deed, and the same is not an acknowledgement of adoption. Nowhere in the gift deed it has been mentioned that the plaintiff has been taken in adoption in the year 1964. Further, both the parties admitted that defendant number 2 and 3 have relinquished their right over the suit properties in the year 1993 through a registered document bearing number 60 dated so and so, which is not brought into evidence by any of the parties, discloses that plaintiff and defendant number 1 performed the obsequious ceremony of their parents and both were in cultivating possession of the suit property by paying land revenue and municipality tax jointly, my lords. Here, my lords, I'm just pausing. This document has not been admitted, my lords. It has not been got on evidence. But still, it has been taken into consideration, my lords. Coming to the next point, my lords. Next finding. The evidence of DW3, that is a present appellant, regarding adoption of plaintiff by his parents to Savitri Amma and the procedures adopted during adoption have not been pleaded by defendant number 1. Taking into consideration the pleading as well as the conduct of the parties, the evidence available on record and the relinquishment deed executed by defendant number 2 and 3 sisters in favor of plaintiff and defendant number 1, and also document Exhibit A, it is crystal clear that the plaintiff was not the adopted son of B. Savitri Amma. The written statement or evidence from the side of defendant is silent about the age of the adoptive mother, whereas, my lords, I have written it in a bracket that Exhibit A reveals the age of the adoptive mother, evidencing that she was more than 21 years. With all these findings, my lords, the learned trial court came to a conclusion that he was not the adopted son. Now, my lords, my humble submissions. My lords, here, paragraph number 4 of the written statement, my lords. From the very initiation of the case, the defendant number 1 appellant has stated in the written statement that there was indeed an adoption, there was a ceremonial function that took place, there was giving and taking of, my lords, the son, this plaintiff, to Savitri Amma. Still, somehow, the learned trial court has come to a conclusion that he had not stated it in his written statement, my lords. My humble submission is, my lords, maybe he has not in a detailed manner, he has not stated the same.
Let us see that.
My lords, my lords. Even I have quoted that part, my lords, still, my lords. The lordship may come to.
Let us see the written statement, original document itself. What is wrong with it?
Yes, my lords. The lordship may come to page number 2 of the written statement. Just after the geology.
Baba, dela. Written LCR do ye thre kariyo bun. Issue deposition version achi pleadings nahi. Written statement by defendant number 1.
My lords.
At paragraph,
Second page, my lords, first paragraph.
this defendant further submits the order.
My lords.
Place it.
Defendant number 1 further submits that during the lifetime of his father, the plaintiff was given on adoption to one Savitri Amma on the Kotha Amavasya day of the year 1964 after observing a function in the family. Since the date of adoption, the plaintiff has ceased to be a family member of Madhava Rao and accepted as the adopted son of Savitri Amma, and thereby curtailing all his rights in respect of the properties of late Madhava Rao. After death of Savitri Amma, the plaintiff succeeded to the properties of Savitri Amma, and even Savitri Amma acknowledged the plaintiff as her adopted son under a registered gift deed in respect of her properties. So, the plaintiff has neither any manner of right, title, interest, or possession in respect of the suit scheduled property or any other property of the father, natural father, Madhav Rao, and not entitled to ask for a partition. Now, I am citing a Honorable Supreme Court's judgment in that respect, my lords. My lords, orange flag, my lords, A. That will be page number.
Paragraph
10, my lords, paragraph number 40.
14.
40, 40.
Yes.
My lords. The Apex Court has opined in this manner, my lords, with respect to the words that is used in a plaint. I would be slow to throw out a claim on a mere technicality of pleading when the substance of the thing is there and no prejudice is caused to the other side. However, clumsily or inartistically, the plaint may be worded. In any event, it is always open to a court to give plaintiff such general or other relief as it deems just to the same extent as if it had been asked for, provided that occasions no prejudice to the other side beyond what can be compensated for in costs. My lords, that means, my lords, here we have very well stated in our pleading that there was indeed an adoption, there was a ceremony, my lords, giving and taking had taken place, my lords. Plus, my lords, in addition to that, in our evidence during examination and cross-examination, also DW3, that is a present appellant, has stated the same thing, and there he has given a little bit more detail, like how the ceremony was performed. If your lordship may come to, my lords, the deposition of DW3.
Yes.
My lords.
Rice, coconut, and banana along with the boy was given to Savitri Amma during the year. Function was performed.
Adoption, my lords. That is 1, 2, 3, 4, 5.
All right. I get the point.
My lords. Hence, my lords, my humble opinion, my lords, my humble submission is that it is open to this honorable court to interpret the same, that we had taken averment to that respect, that adoption had taken place, my lords. My second submission is, my lords, the object of adoption, as mentioned in Mullah Hindu Law, 21st edition 2010 by Satyajit Desai, my lords, are twofold. The first is religious, to secure spiritual benefit to the adopter and his ancestors by having a son for the purpose of offering funeral cake, add libations of water to the soul of the adopter and his ancestors. First object. Second object is secular, to secure an heir and perpetuate the adopter's name. My humble submission is in this way, my lords. In the present case, this lady, Savitri Amma, is an unmarried lady and sister of B. Madhava Rao, the father. For which reason, in my humble opinion, my lords, this possibility of adopting one of the sons of the brother, my lords, cannot be thrown away, my lords. Moreover, in all the evidences that has been adduced by the defendant witnesses, all have said that he is the one who has performed all the obsequies ceremony of late Savitri Amma. Which means, my lords, in my humble opinion, that the spiritual benefit part, one of the objects of adoption, has been fulfilled here, my lords. The purpose for which adoption is done, first object.
No, let us go to the finding first now.
My lords.
Let's see the finding.
My lords.
The trial court disbelieved your, isn't it?
My lords.
How did the trial court decide this issue?
trial court has taken into consideration only the evidences that has been given by PW's, my lords. DW's evidences had not been taken on consideration by by pointing out small latches and lacunas, my lords. That, for example, DW1, my lords, he said that he has heard that adoption had taken place. He has not seen it. DW2 has been in the ceremony, but when he was asked about the name of the Purohit, he could not name the Purohit. Of things, my lords, contradictions has led the court to come to a conclusion that these witnesses' evidence are not credible, cannot be relied upon. Whereas plenty of witnesses have all stated that no, he was not the adopted son of Savitri Amma. On that basis, the learned trial court has come to a conclusion. My lords, the first object, according to my humble opinion, is fulfilled. Second object, my lords, that is secular or to secure an heir. My lords, DW1, 2, and 3, they have categorically stated in the examination, cross-examination, my lords, that from the very beginning, this person was living with Savitri Amma. He was staying with Savitri Amma, and after the death of Savitri Amma, by whatever mode it may be, now he owns the property of Savitri Amma. According to them, it was a gift deed. But still, now he is the owner of the property. According to my humble opinion, my lords, it fulfills the second object, that is now she has an heir to look after the property of Savitri Amma. My lords, my third submission, I am again relying upon a Honorable Supreme Court's judgment, my lords. Lordship will find it in yellow flag, my lords. This specially deals with those kind of cases where the fact of adoption has come into question after a long period of time. Your Lordship may see paragraph number 7 of that judgment, my lords. While considering the question of proof, my lords. Your Lordship got it? My lords. While considering the question of proof of the adoption pleaded, we must bear in the mind the fact that the same is alleged to have taken place in 1892, nearly 54 years before the present suit was instituted. Here, almost 40 years has passed, my lords, in the present case. Therefore, naturally, it was extremely difficult for so-and-so to adduce any oral evidence in proof of that adoption. All the persons who could have known about the adoptions are likely to be dead. Shyam Bihari Lal himself could not speak of the adoption. His evidence is at best hearsay. Then your Lordship may kindly come to paragraph number 9. There is no doubt that the burden of proving satisfactorily that he was given by his natural father and received by Gopal Das as his adopted son is on Shyam Bihari Lal. But as observed by the judicial committed of the prior son, as a fact, yet from the long period during which he had been received as an adopted son, here, my lords, is important. Every allowance for the absence of evidence to prove such fact was to be favorably entertained. Then, my lords, may kindly turn the page to paragraph number 10, my lords. Last. There's the last thing I'm relying upon in this judgment, my lords. In the case of all the ancient transactions, it is but natural that positive oral evidence will be lacking. Passage of time gradually wipes out such evidence. Human affairs often have to be judged on the basis of probabilities. Rendering of justice will become impossible if a particular mode of proof is insisted upon under all circumstances. In judging whether an adoption pleaded has been satisfactorily proved or not, we have to bear in mind the lapse of time between the date of alleged adoption and the date on which the concerned party is required to adduce proof. These 3 points, my lords, of the Honorable Supreme Court, I am relying upon, my lords. Here, my lords, similarly, what has happened is DW1 and 2, whose evidence the learned trial court has not taken into consideration, as I had, my lords, stated earlier, that just because this person has not attended DW1, has not attended the ceremony, he had heard about it, the learned trial court has discarded the evidence. DW2, who had attended the ceremony, his evidence has been discarded on the ground that he could not name the Purohit. And later on in cross-examination, he has named some random name as Purohit. DW3, on the other hand, the present appellant, he has given why the village men and caste men were not brought into for evidence. That was another finding. My humble submission, again relying on this Honorable Supreme Court judgment. 30-40 years has passed in the meantime. People at that point of time who were elder, they must have either passed away, or who were young fellows, they are not in a position to remember names. Then my next submission will be as such.
We'll take it up next week. Not in part. Let's just matter next week. Yeah. Okay, I'm okay. I'm okay.
Wait for a minute.
Let us grant another opportunity. If he can appear, he'll appear. If he doesn't.
Grateful.
Item number 43.
Caligro, pass over.
Item 45.
Respondent pay.
Yes.
Respondent pay appear within Mr. Nandor Singh.
So what? You argue. If he is not there, he is not there. If he is not there, he is not there. Unless you are not ready, that's a different matter.
ନାଇଁ ମୁଁ ରେଡି ମୁଁ ଖାଲି ଗଲା ତ ଟାଇମ୍ ଥିଲି ମୁଁ ଲୋକଙ୍କ କିଛି ଜଣା ନାହିଁ ତାଙ୍କୁ ଚିଠି ପଠେଇଛି କିଛି ଆସିନି ଅଦରୱାଇଜ
I don't know what you say. Whatever. 2017 matter.
Yeah.
You are there, Mr. Mishra, in this case?
45.
45.
46 we are on. 46 No, my friend is also there in 46. 45.
So 45, we are on 45.
Yeah.
What do you want?
ଆଉ ଗୋଟେ ଦିନକୁ ଯଦି
ସେଇଟା କହିବେ ତ ମୂଳରୁ।
ନାଇଁ ନାଇଁ ମୁଁ ସାର୍ ରେଡି
ବିଭିନ୍ନ ପ୍ରକାର କଥା କହିକି ଆପଣ କହିଲେ ମୁଁ କିନ୍ତୁ
ନାଇଁ ସେଟା ଆଡମିଟ କରିଛନ୍ତି ତାଙ୍କୁ ଏଗ୍ରି କିନ୍ତୁ ସିଏ ଖବର ଆସି ନହେଲେ ମୁଁ କରିଦେବି କାଳେ
All right. Sri Pondal and counsel for the appellant wants a short adjournment in order to take instructions from his client. List this matter.
Commencing 5th August.
The week commencing 5th August. Yes.
Item 46.
Item number 44 was moved to 46. And item number 3 was passed.
Yes.
So that is correct.
Item number 3 ରେ କଣ?
ସେଇ ସେକେଣ୍ଡ ବିଲଟା ମୁଁ ଆର୍ଗୁମେଣ୍ଟ କରିଥିଲି ସେଇ ଯୋଉଟା ସେଇ ଘର ଆଉ କ୍ୱେଶ୍ଚନ ଥ୍ରୀ was that this sale deed was Melody.
Melody, yes. We'll again call it tomorrow. As the pass over ହେଇଗଲାଣି.
Sir ଆଉ କାଲି କି ନ କରି next week କରନ୍ତୁ.
All right. Next week. Huh?
29.
Item 3. Huh? In the week commencing 29 July.
Saturday chapter.
Saturday नहीं? कितना ही हो?
आज सहीला सर.
अच्छा. ठीक है. देखिए आप
चारटा पाटा
हैं? Oh. Yes. Yes, item 46.
Yes, my lord.
Is the LCR there? I don't find the LCR. LCR is not there. Is it necessary? It is not necessary.
LCR has come because we have been given a soft version of the LCR.
Tell Thibo.
Our office has got the soft version.
So it must be there.
The point is very simple. The first point, the lordships would see the defendants are the appellants. It's against a confirming judgment. The suit was for declaration of right, title, and interest. Now, the first point on which the appeal has been admitted on 6/4/2018 was whether the first appellate court erred in law in not disposing of the petition filed under Order 41 Rule 27 of CPC either separately or in the judgment. This is the first question. Now, this question can be answered only by a perusal of the order sheet.
Order sheet of the court below.
Of the lower appellate court.
Yeah. Which are the orders you want me to see?
My lord may see order dated 21/6/2017. our office has found out that it's PCR, it is there at page 80. The pages may not have.
21/6/2014, counsel for the appellant files a petition under 41 Rule 27.
21/6/70.
Yes.
Thereafter,
Put upon 5/7 for hearing
my lords,
of the appeal.
for hearing of appeal. Then from that
And
date onwards,
consideration. In the meantime, petition considering during hearing of appeal as last as.
thereafter, my lord may see there are 2-3 orders on. So this petition remained undisposed. So this is the first infirmity in the judgment. We had filed a petition.
Has he not dealt with it in the judgment?
Neither in the judgment nor in the order sheet. That's the question for me.
Yes.
So on this short point, if your lordship will consider and send it back, that's one also.
So what evidence did you want to adduce as additional evidence?
Now that petition,
You are the defendant.
I was the defendant.
So the suit was decreed.
Now, food was decreed.
Yes.
Now we wanted to bring in a certified copy of the police report in a criminal case. That was the document.
How is it relevant? How is it necessary?
It would have been a document pertaining to possession of the defendant. So we are on the procedure. If your lordships will go into that issue, that whether as such this petition was devoid of merit, then that's a separate issue. Then the other two questions would come up. But rightly or wrongly, a petition was filed. The court below has not considered it at all.
Yes, what do you say, Mr. Ponda?
Yes, my lord, I argue because that on that point, my lord, already the London Trial Court and First Appellate Court has given finding with regard to possession.
See, there are two things. First, mechanically, only because the petition was not considered, I will be rather slow to remit it on that ground. But then I would like to see whether that petition or that evidence, whether it will have a material bearing on the outcome of the case.
My lord.
If this court is convinced, yes, it may have a bearing on the outcome of the case, yes. Then we can direct the First Appellate Court to consider it and hear the appeal again.
My lord.
So it would be better if you place the facts. Mr. Mishra.
My lord. Then in that event, the lordship may, then we'll have to prepare a full note because the other 2 points are regarding evidence.
Okay.
But this, I would submit then my lord, of course, the lordships can see the merits of the petition itself here.
Yeah, see, this is against a confirming judgment, isn't it? Suit was decreed. Some order, I have not seen it, but from what I hear from Mr. Ponda, some order has been passed with regard to possession. Some finding is there. Now you want to upset that finding by relying on some.
On a specific question that if a party files a petition, it may not be worth considering, but the court below has to at least, this is a fundamental error of procedure, which your lordship.
True. But whether that procedure, whether it will have a material bearing on the outcome of the case. Otherwise, why there will be unnecessarily a remand? Why will there be an unnecessary remand only on a technical point? If it is required for the ends of justice, even here also that evidence can be taken. Isn't it?
Then my lords, then
let us hear it. What is the
then your lordships, I'll have to address your lordships on the other 2 questions. And then your lordship can consider.
Yes.
Let me keep it to
go to
any date.
Week
commencing 12th August.
Week commencing 12th August? Yes.
Interim orders to continue.
Yes.
जल्दी था कहना एग्जीक्यूशन का स्टे ही ताकर
12th August तो डेरी कौन होची
सर जो डिलीवरी माने कमिश्नर वाज अपॉइंटेड but now it hasn't stayed.
No, rightly stayed. देखियो अब ଆମେ appeal ଛୁडू से सेपटे कमिश्नर आपण को धरि पळेबे आपण
State ଅଛି सॉरी हे गला.
Yes, no. Does this matter in the week commencing 12th August? Interim order to continue. Item 16 of this list. Supplementary is how खोलिबो जा आइछि. It has been disposed of.
So there's a case, Mala, sir, prepare the case.
Okay, item 16 next week. Yes.
Item number 48.
Judgment
for the respondent. There is an introductory order. Status quo. That is why we are not in a position.
Yes, I could not hear you. Sorry.
The confirming judgment.
Yes,
I am for the respondent. Nobody is appealing. But
nobody is appealing for the.
And the interim order is operating against me. That is the problem because that is why.
So I will do one thing. I will pass it over. It has to go till it is in the weekly list. So it has to go till Friday. Thereafter we'll see. 2019 matter though.
So Friday I will be not there, but tomorrow I am there. I'll wait for tomorrow.
I think Mr. Mishra, you can inform Mr. Das
Yes.
that the matter is to be taken up
Yes,
tomorrow.
yes,
For whatever that is, both sides should be there. I'll hear it, whatever is there.
Right.
All right. He may also be thinking that since it is in a weekly list.
Right.
Pass over.
Item number.
Please inform him.
Yes.
Yes, Mr. Mishra. Please inform.
Item 51.
My lord, item number 49.
49 कौन सी?
We commencing 29th July.
अच्छा, senior advocate mention
What the appellant, my lord?
29 July. मैं next week रहे.
Senior is ready to do the matter today.
Yes. Yes.
Item 51.
Item 51 are taken up next week.
All right, next week.
It will be complete.
It's tomorrow to complete.
Item 52.
52.
Sir, my lord, on behalf of Mr. Vijay Raut, I want to say that his wife is sick. He has accompanied her to the hospital. So it may be next week or
Prayer for adjournment is made on behalf of Sri D.K. Rautrai, learned counsel for the appellant, on the ground of illness of his wife. Let this matter
We commencing 5th August.
in the week commencing 5th August. Pass over.
I'm afraid one thing, ma'am. Item 50. The appellant is taking deliberately time.
Item 50.
Item 50.
One is
Weekly list.
Passover 44 or 50.
This has been passed over. This has been just passed over. Tally.
So, right.
Interim order is there, my lord.
Interim order will continue.
Passover item number 11.
Yes, item 11.
Yes, that matter where your lordship has been pleased to grant permission for the state who was not implemented as a party.
Yes.
In either of the courts.
Yesterday some order was passed probably. No,
Your lordship wanted to hear if any substantial question of law involved.
Yes.
Since the other side though took time to file objection to.
No, that not. That have taken time twice.
Yes.
Yes.
So your
you
lordship said
you
that we
submit.
can proceed.
You can submit, please.
Here is a case where initially from the inception, there was a suit for declaration of right title interest, confirmation of possession and consequential relief. The trial court framed issues with regard to if the plaintiff has right title interest and all that, that is issue number 1, 2 and 3 were the issues relevant and taken by the trial court together.
Yes.
The answer was, since it stands in the name of the state government and state government having not been implemented as a party, the suit is not maintainable. Accordingly, it was dismissed. Appeal was preferred by the plaintiff. In appeal, the first appellate court, under a misconception that Odisha State Financial Corporation being a state government undertaking and being a party in the suit, so the suit cannot be made to fail on the ground that state is not a party. That is the sole basis on which the first appellate court has allowed the appeal.
Yes.
Declaring right title interest and all the consequential reliefs.
Yes.
So the first ground I have taken is non-implementation of the party who is a necessary party.
Yes.
That is at page 8 of the memorandum of appeal. Whether the suit of the plaintiff could have been allowed by the first appellate court in absence of state, who is a necessary party as has been found by the trial court on the basis of the evidence on record. And the second is whether the first appellate court is correct in ignoring the necessity of the state as a party in the suit by holding that OSFC is a government of Odisha undertaking. So these are other grounds I have taken, but
I think
these are
first and
the-
two, 1 and 2 are,
my submission is that these are the
so
substantial.
first we have to pass order in the petition.
Yes.
And there's a delay also.
Yes, the delay
delay
also I have
notice-
explained how it got.
Notice was issued. I think Mr. Mishra, Hon'Ble Mishra was appearing.
Yes, he took time to file objection, but maybe that his name having not been reflected, he might have missed it.
Then, if that is so, then we can take it up tomorrow.
As your lordship please.
And I'll, Hon'Ble Mishra টি জনাই দেবো। ফোন করে জনাই দেবো যে কালি ব্যাটাটা আছে। হ্যাঁ? It is in the weekly list. Let us wait, give him
Till
one.
Friday.
And his name is not there, so.
But your lordship wanted to know what is the substantial.
I got it, I got it. But there's a delay.
Yes, that
Delay in
the
filing of the
other side,
petition
it's
for
in
leave.
the right
So it is-
accrues, yes.
Yes.
So item number 12.
Please, your lordship. Item number 12 is for substitution of the respondent number 4, 3. There's a delay
789.
of more than 5 years. My submission to that effect, your lordship, is that if my lord may peruse the appeal memo, the first appeal has been passed against the dead persons, your lordship.
Okay.
Now, by the time the first appellate court passed the judgment, all these three respondents and appellants in the lower court were already dead. So hence, effectively, that judgment becomes nullity. So if
It's a nullity insofar as these deceased respondents are concerned.
within these respondents, 2 of them are appellants, your lordship, and one is the respondent number 2 before the first appellate court, your lordship.
Yes.
So, for regularization, your lordship, the delay is 5 years for respondent number 2. After the notice was issued by this honorable court, the endorsement was that the said party is dead. Only after that we came to know that the said person is dead.
So this appeal has been admitted?
Yes, your lordship. By order dated 9/11/2023 से तो ये है मैं admit है ना notice.
No, if you say, I think there is. Come to paragraph 3 of the petition for condemnation of delay.
Yes, your lordship.
कौन लिखा है?
When the notice from the concerned person returned unserved with an endorsement dead, this honorable court wide order dated such and such directed for taking necessary steps, and after which the present petitioner made query and accordingly have made the respective applications.
But now you are saying that he was already dead when the first
Yes, sir.
appellate decree was passed or the
Yes, sir.
judgment was passed.
The present appellant, your lordship, was the respondent number 1 before the first appellate court.
So there is no conflict of interest.
It is a reversing judgment, your lordship, wherein the suit was dismissed, but the first appellate court.
Is it necessary to substitute at this stage?
That is the point of law that has to be gone into.
Because the judgment becomes a nullity. You can ignore it. You can ignore the nullity judgment.
But your lordship, the judgment passed against the present appellant.
That is this.
Binding.
That is binding. So what will be the point of law here?
Some time may be given.
You examine it.
Yes, sir.
What will be the effect of? Because it's not a question of he died during pendency of the first appeal.
Yes, sir.
At least when the judgment was passed, he was already dead.
Yes,
so
sir.
that judgment becomes a nullity insofar as that the respondent is concerned. So whether in such a situation is he required to be substituted by the second at the second appeal?
Yes, your lordship. I'll verify this question.
All right, you just find out.
Yes, sir.
Let's this matter next week.
Much obliged.
Then?
Sir, I started Friday.
Okay.
So item number 24.
24? Oh, all right, pass over.
So item number 28.
This is for admission. Yes, sir. Yesterday, I think this matter was being.
He was doing it.
Yes.
Your Lordship put one question actually was the jurisdiction part actually. And Your Lordship rightly
He has
said-
called you. He has called you.
No, I was sitting there. In fact, I wanted to ask.
I had asked him a question. He should have answered it. He has called you, sir.
Can I just say actually?
Please.
As Your Lordship rightly said, the court doesn't have the jurisdiction. So he said he is difficult on his part to concede. Therefore, I have come.
He should have conceded.
But sir, in my concession, there is a point.
Yes. No, why should I record your concession?
No, number one, the document has not been called for from the department, let's say a sale, which was executed at Hon'Ble.
Yesterday, I asked him that question. What part of the cause of action, according to you,
Exactly.
arose within the territorial jurisdiction of Hon'Ble?
Now, this is a claim against OP number 4, not against sale. So the agreement was executed at Hon'Ble. A photocopy was presented in the court. Court taken note of that, said it's not admissible. Obviously, it is not admissible, so it has not been exhibited. Therefore, that was not taken into consideration for the purpose of adjudicating the jurisdiction part. An application was filed to call for the document. The High Court has given a finding, in fact, if you kindly see. Thirty? 39. Yes, 39. 39 repairs.
39 of the trial court judgment.
39 running plus 39. Running plus
Running
39
plus
of the
39, okay. Yes. Issues.
Paragraph 5.
Yes.
This court rejected the said application. That application was filed for interim maintenance and all those things. Against the said order rejection, petitioner of preferred writ application, while disposing of the writ application, the Honorable Court observed, considering the rival submission of the parties after going through the impugned order, it appears that trial court, without giving a chance to the parties and hearing the matter in the question of jurisdiction or Order 7/11, has passed the impugned order, held the court has no jurisdiction to try the case, set aside the impugned order and directed court below to hear the matter afresh. Then an application was filed to call for the document that was also not entertained. He said it is your duty to obtain a copy and file it.
Sure.
So that document is the vital document actually to decide the jurisdiction.
You have a copy of that document?
Photocopy. Yes, I do have a copy. A copy. Right, agreement notes. No, the agreement copy is like should have undertaken file each.
We can take it up tomorrow if you can find out.
1 second.
I just want to see that document.
Right.
If it can have a material bearing, then matter is different.
Yes.
If it doesn't have, then
If that document has been executed at Hon'Ble, then the jurisdiction
Yes.
lies at Hon'Ble. So since the document was not called for, it was not actually entertained, and therefore court has rightly said doesn't have the
so
jurisdiction.
it could have also been filed at the appellate stage, lower appellate court.
Yes.
File alone
No, exhibit one. Sir, exhibit one, the record is there.
देखिए नहीं it is a admission actually बिल्कुल call for any LCR that is why I am asking whether you have the copy.
1 second, Lord. Just 1 second.
So there is no issue, we can take it up tomorrow, sir.
If I can get it. Right. No, I'll try to get it.
Sir.
The other point is, supposing I don't get the document. Let us assume I don't get the document. It doesn't have the jurisdiction. Also, kindly have a look at Order 7, Rule 10.
You should have returned the plaint.
Order 7, Rule 10A says, sir, kindly have a look at that. CP study.
He has to make an endorsement on the plaint and return it to be presented before the appropriate court.
Yes.
And in fact, that very plaint has to be presented.
Yes.
Considering the
limitation can be saved.
Yes.
And appellate court also can do it.
Sir.
Appellate court also can do it.
Yes.
Order 7, Rule 10 kindly see first. Ten says, return of plaint, subject to the provision of Rule 10A, the plaint shall at any stage of the suit be returned to the representative in the court in which the suit should have been instituted. Explanations for the removal of doubt, it is hereby declared that the Court of Appeal or revision may direct, after setting aside the order passed by in the suit, return the plaint on the sub-rule. On the
same power can be exercised.
And if you also turn to 10B.
Yes.
Power of the appellate court to transfer suit to proper court. Even court can send the record to the court where the suit should have been filed and transfer it, directing parties to appear on a particular date.
Sure.
That power is there. This case has not been decided on merit. Therefore, in the event I fail to show the document, then your lordship may direct this, set aside the order, direct the plaint to be either returned or presented in the proper court.
That right should have been given. If he took the view that no part of the cause of action arose, then that could have been done. Normally, that is the
procedure.
Here
it has been dismissed. Tomorrow, if lordship.
Pass over for the day. Huh?
So write a note 32.
Here, if lordship direct, then the orders have to be set aside. The trial court should be directed to either return or present it.
Item 32. Yes.
To my lord, the appellant is the plaintiff.
Yes.
In the court below and against a confirming judgment. But here the two questions, your lordship's kind consideration. One is, my lord, defendant number 1 is she states to have got the property from a compromise decree in the year 51. And that property in the compromise decree, her right over the property has been stated to be of limited interest. She says that by virtue of coming into force of the 1956 Act and with regard to section 14 subsection 1 of the Act, such limited right has
crystallized into
yes, absolute right.
Absolute right.
And therefore she was entitled to sell the property and deal with it in the manner she likes. Now this portion is the subject matter of challenging the suit, where the plaintiffs claim that such right which came from the 1951 decree could at best be recognized under section 14 subsection 2 of the Act. Lordship will kindly take up the section 14.
Hindu section Act. Hindu Succession Act, section 14.
Section 14.
Yes.
I'll just place it for your lordships.
Yes.
Any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held by her as full owner thereof and not as a limited owner. Lordship will then see subsection 2. Nothing contained in subsection 1 shall apply to any property acquired by way of gift or under a will or any other instrument or under a decree or order of a civil court or under an award where the terms of the gift, will or other instrument of the or the decree, order or award prescribe a restricted estate in such property.
So you are on this.
I'm on this, Milord. So this is in fact, the main question that falls for your lordship's kind consideration in this appeal as to whether the case of defendant number 1 falls within section 14.1 or 14.2. If it falls within 14.2, she certainly could not have sold the property.
So what was the finding then?
Finding is that it is under 14.1.
Let us see that finding.
Yes.
What was that original? It was a decree.
Yes, Milord.
So on the basis of the decree, she got limited right.
Yes. So I'll just explain that in one line, Milord.
Yes.
Because the finding is no particular finding, it runs into pages.
Yeah, that's all right.
But what the finding is that since she had a pre-existing right over the property that flowed from her deceased husband, that right has crystallized into 14.1 and not 14.2.
That has to be examined.
Yes, Milord.
It has to be examined.
Because what my humble submission is, pre-existing right would have occurred if there was a definite share in respect of her husband. Suppose it was a self-acquired property of the husband.
No, Mr. Mishra, tell me, what was the original suit then?
No, there was no suit.
What the original decree thila?
Sir, original decree was suit for partition.
That OS numbers one suit?
Yes, 51. OS partition jo suit ta file hitla, sir. In that suit, there was a compromise decree.
Okay.
Where she filed an affidavit, the defendant number 1 herself, saying that such property, if given to me, I will be using it as a limited interest. Now, whether such property came to her through her husband or not, that is to be examined. That the learned courts below have not examined. Merely because it is a co-parcenary property, the courts below have come to the conclusion that she had a pre-existing right. But pre-existing right in respect of a self-acquired property is different.
Yeah, I'm still unable to understand this pre-existing thing because you say that it was a compromise decree.
Compromise decree arising out of a partition suit.
All right.
It's a joint family property.
So this suit is disposed of in terms of the compromise.
Yes.
That is the decree.
Yes. And that decree translates to 14.2, not 14.1.
That's a different matter.
We'll see.
That's a different matter. I'll have to go through that decree, compromise decree.
Yes.
We have to see what is the recitals of those compromise.
Yes.
But then so that suit was decreed in 51.
51.
Now, what led the plaintiff to file the suit?
Because the defendant, number 1, started alienating the property, citing the property to be her absolute property. So that led to the cause of action to file the suit for cancellation.
Okay. Now, what the trial court held?
The trial court held the property has vested in her absolutely by virtue of 14.1.
Okay.
And that was confirmed by the learned appellate court. But this pre-existing part, well, it's in my humble submission, they have erroneously construed and interpreted the law, where the pre-existing would have been if her husband had a right over the property in specific nature of the property that was given to her.
Okay. And what about the appellate court, lower appellate court?
Same finding, Lords. It was simply confirmed.
All right, we'll admit it. Heard Sri Somya
That's why
I'll admit it. Heard Sri Somya Mr. Learned Counsel for the appellant. Peruse the impugn judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law.
Let's that's page number 17.
Yeah, the one
again. J1 as well as Milord 4. J4 is also very important.
All right. Is admitted on the following substantial questions of law. Page number 17 to 1 lekha or 4 lekha. Sir. Issue notice. To the respondents by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. Does this matter? September.
30th September.
30th September 2024. Call for the LCR. What IA?
There's no third party interest, subsequent alienation.
It is directed that in the interim, no third party interest shall be created in respect of the suit property till the next date. In the interim, I guess.
I'm grateful, Milord.
So I don't know, 38.
It's a very interesting question.
Very interesting, Malad. Very interesting.
But the terms of the compromise deed have to be read
Yes, Malad.
very, very carefully.
Absolutely. So I bow down.
It just cannot be decided on the face of it.
But what the learned courts will have done is they've obliterated 14.2. That could not have been done.
Okay, let's see. Yes.
So it's 38, Malad, may I do it tomorrow or day after?
38?
Yes, Malad. It's a hearing matter.
No, pass over for the day.
Pass.
But get ready tomorrow.
Tomorrow, Malad. I'll get ready. I'm obliged.
Yes. Then?
43.
Huh?
Pastor, I don't know, 43.
Anybody else? Anybody else available? 43? All right, pass over. Remaining matters passed over. If you can inform Mr. Mishra also. His name
junior
So tomorrow we'll take it up. Any order we pass, let it be in presence of both parties.
Better, yes.
Yes. Why should somebody feel aggrieved?